This webinar is entitled What's New in Infrastructure Development. Thank you so much to all of you who have joined the session today. We hope that you'll find the presentations that you're about to hear helpful, and we look forward to some discussion in the light of the points that are made by the speakers, and we hope that you'll find the proceedings informative. My name is Tim Mould QC. I'm the chair today. I'm joined during the session by my colleagues Neil Cameron, QC, Jacqueline Lean, Andrew Byass, Heather Sargent and Richard Turney. You'll see their mugshots and the topics that they're going to be talking about on the screen now. I'll introduce them a little more formally when we come to each of their talks. Just a few housekeeping points before we kick off. Your microphones are automatically muted, so you will not need to adjust your local settings. We very much welcome questions from you throughout the session. Please submit them via text on the Q&A section, which you'll find at the top or bottom of your screen. If you'd like to remain anonymous when asking a question, please make sure you tick the Send Anonymously box before submitting your question. We'll try to answer as many questions as possible at the end of the presentations. This is being recorded, and you'll receive a link to the presentation and the recording shortly after the event concludes. If you lose connection at any point during the webinar, no problem. Please just rejoin the meeting by clicking on the original link once more. So let us begin. The programme is due to conclude at 1:30, and the published programme had a talk by Heather Sargent as our first talk on the Stonehenge case. We're just reversing the order slightly. Richard Turney is going to give his talk on habitats of net gain first off, and then Heather will follow him, and then we'll have Andrew Byass talking about the Sawkill case before we go to our first question session, and then a short break towards the end of the morning. So over to Richard. And Richard, I should say, is, as many of you will know, is a specialist in planning and environmental and public law. He has a particular experience in infrastructure projects. His recent work includes acting for applicants, local authorities and local residents on development consent order schemes, including Hornsey 3 offshore wind farm, the Stonehenge scheme, and the Aquin interconnector. He is well known, acted for Heathrow Airport on the airport's NPS litigation to the Supreme Court, of which more later, and previously acted for the Secretary of State in promoting the first phase of the HS2 high-speed rail programme. He's recently been advising government on biodiversity net gain provisions in the Environment Bill, so he's well placed to speak about the topic which he's about to address. So let us ask Richard to present his talk.
Thank you, Tim. Good morning, everyone. I'm going to talk about habitats and net gain as two sort of topics that are quite prominent in the field of major infrastructure delivery. Just, those are my two topics. Go straight on to deal with habitats. I think the first point to note is not a development, but the opposite of a development, namely that the habitats regulations as they stand are effectively unchanged after Brexit, apart from a few consequential amendments on the fact that we're no longer part of the EU. But the concept of a European site, the protection afforded to it, the substantive protection afforded to it by the habitats regulations is unchanged as things stand. I was thinking about some of the common issues that I've seen in major infrastructure projects where there is an interaction with a European site. And I should say that in my experience is many, if not most, major infrastructure projects have some sort of interaction with a European site. These are the issues that I think are particularly prominent at the moment. The first one is a sort of conceptual issue and an issue of approach, which is the combined effect of requiring a precautionary approach to assessment of impacts on protected habitats and promoting infrastructure projects with the flexibility that is sometimes described as the Rochdale envelope approach. That is to say, to taking projects, setting parameters for the projects rather than defining specifics such as scale of particular piece of infrastructure, routes of cables and so on, providing flexibility within the proposed consent. And of course, you end up then with a sort of double worst case, because you have to assume both that your Rochdale parameters are reached in the worst possible way for the protected site, and secondly, that the impacts that are assessed on a precautionary basis. And I think there's a risk in doing so that one ends up potentially just overstating and going beyond a reasonable worst case assessment to something that is more profound. The next point relates to this, which is addressing de minimis impacts. On its face, the protection for European sites does not contemplate a de minimis principle. But I think it's broadly recognised that some kinds of interactions between projects and European sites are so fleeting and perhaps so unlikely that they can be disregarded for the purposes of assessment. But in doing so, obviously, there's a risk. There's a risk that one understates, and there's a risk that a conclusion which is reached about any interaction being so unlikely or so fleeting and insignificant that it doesn't need to be assessed, that the person who is required to carry out that assessment, the decision maker, may reach a different conclusion. The next point, which I think is a regular issue, is dealing with habitats in poor condition, where minimal adverse effects may be regarded as a negative effect on integrity because the habitat in question needs to be restored. And then the final point is developing a derogation case. I'm going to say a little bit more about that by way of an example. So this is my example, Hornsea 3, a project that I was involved in, which has now got development consent. And it's just a good example of the way in which habitats issues arise. The examining authority recommended refusal on habitats grounds, and I'll come on to the detail of that. The Secretary of State engaged in further consultation on the habitats issues after the examination had completed. That in itself was a little controversial, and I've set out the relevant part of the Secretary of State's decision letter in my slide. But in essence, the Secretary of State was concerned that proposals in respect of compensatory measures developing in a ropey case really needed to be the subject of examination and couldn't be left to the point at which the decision maker expresses a view that they depart from the applicant's assessment and conclude that there are adverse effects on the integrity of European sites. And I think that is a sort of bit of a warning shot for other developers. If there is a chance that the examining authority and the Secretary of State will conclude an adverse effect on integrity of a European site, then the applicant really needs to be facing that through the application process and through the examination process, and identifying, if necessary on a without prejudice basis, the approach to EROPI, to compensation that the applicant would promote if a conclusion is reached that there is an adverse effect on integrity. So just looking a bit at the detail, the key issue for the examining authority was the impact on two SACs from the export cable, and in the absence of compensation, it recommended refusal. Now both of those had issues with their condition, relevant to one of the points I've identified as a major issue. The Secretary of State took a different view, concluding that as well as the SACs, there was an impact on the Flamborough and Filey Coast Special Protection Area for birds through bird collision risk from the wind turbines, and said that that effect couldn't be ruled out. That led, as I've already said, to further consultation, quite extensive consultation and engagement between the applicant and Natural England, RSPB and others, quite detailed representations on the issues. The Secretary of State, having received that further consultation and engagement post examination, went on to apply the Ropey test and concluded that there were no alternatives and there were imperative reasons of overriding public importance to justify the delivery of the scheme, which was a huge contribution to the targets for offshore wind delivery. And the Secretary of State accepted the compensation strategies for both kittiwake, that's the collision risk, and for the sandbanks in the SACs, and accepted that those were suitable and appropriate strategies which could be relied on for the purposes of granting development consent, subject to further details being provided under requirements. So that was the substance of the decision. I think it's worth just reflecting on the key lessons from that. First of all, as I've already said, making sure that even if it's on a without prejudice basis, there's an indication as to how matters such as compensation will be dealt with. I think the other key point is that obviously this is a direct acceptance of the Ropey case for renewable energy. From my perspective, I think that's an important recognition, and for many applicants should be something that is a welcome route through this problem. In other words, if you are facing a situation in a renewable energy scheme where there are potential impacts on European sites, the Ropey case is really already made for you by the Energy National Policy Statements. That's a case of pulling out that information, developing it for the scheme specifics. And in terms of alternatives, obviously, that there is a way in which one can argue it through for the number of sites that are available for these types of projects, and the fact that, as recognised in the energy NPSs, we need as much as possible, and therefore complete scheme alternatives really are not reasonable alternatives at all. So that's an example of the issues in practice. Briefly then, what can we anticipate in the future for habitats issues? Well, there's currently a bit of uncertainty as to whether there are going to be substantive changes to the habitats regulations. Clearly, at the moment, they are broadly as they stand, and therefore we have to just sort of proceed on that assumption that they won't be changed, even though there are, of course, powers to do so as a result of those provisions being derived from community law. Secondly, the Environment Bill says a little more about protected sites generally, and those include European sites, and there's a provision for what are called protected site strategies being developed by Natural England, which may lead to a more concerted effort to record and detail the approach to any particular protected site, which will obviously feed into any assessment of impacts. And I think, again, going back to the theme from Hornsea 3, I would say a growing need to consider Ropey and compensation issues at early stages of project development, combined with the precautionary approach. In my view, these sorts of things really should be grappled with quite early in project development. And I take the view, with which I know some disagree, but I take the view that really we should be facing up to Ropey for large-scale renewable energy schemes. It's precisely the kind of need that was contemplated in the development of the Habitats Directive and the regulations. It is there is more risk often involved in seeking to find ways through assessment to say there is no adverse effect on integrity, than there is to say, well, if there is an adverse effect, which we may or may not accept, then this is the strategy. There is a ROPE, there's compensation available, and that being done sooner in the project, earlier in the project, is a valuable route. Now, that says nothing about the complexity of compensation measures, and obviously many on this call will understand that the compensation measures themselves can be complex and difficult, and there's certainly all sorts of issues around that. But in my view, really taking an approach of facing up to compensation early on in the project's lifetime gives a degree of robustness when it comes to examination. So I'm going to move on to the topic of net gain for the second half of this talk. In terms of NSIPs, there's currently no requirement to deliver net gain. Obviously, we've seen changes to the MPPF when we're dealing with applications under the Town and Country Planning Act to support a requirement for net gain, and there are further changes coming in respect of those provisions. Focusing on NSIPs though, the position really is confirmed in the recent consultation on the Energy National Policy Statement Suite, and the draft new EN1 notes that there is no obligation for projects under the Planning Act 2008 to achieve net gain, but goes on to say that energy NSIP proposals should seek opportunities to contribute to and enhance the natural environment by providing net gains where possible. And then it says applicants are encouraged to use the most current version of the DEFRA biodiversity metric to calculate their biodiversity baseline and inform their biodiversity net gain outcomes, and to present this data as part of their application. So the draft is saying both you don't need to show net gain, but also you should assess net gain through the metric. And then it explains that biodiversity net gain should be applied in conjunction with the mitigation hierarchy, and it does not change or replace existing environmental obligations. So that's the kind of direction of travel, the sort of latest, obviously it's a consultation draft, but it's the sort of latest statement of how government is thinking about net gain in the context of Planning Act proposals. But the footnote to the draft EN1 refers to the Environment Bill and its provisions in respect of net gain. So turning now to those provisions, these are relatively recent amendments to the Environment Bill. Those familiar with it will know that the Environment Bill is a major piece of legislation, very significant piece of legislation, which sets up a range of different new structures for dealing with environmental matters, the Office of Environmental Protection, and makes various other provisions, including in respect of a statutory duty to achieve net gain on planning applications under the 1990 Act. For the 2008 Act, the provision is relatively recent. It was introduced by way of an amendment earlier this year in the context of a bill which has been before Parliament for 2 years now. The recent amendments are looking to place a net gain, biodiversity net gain obligation on schemes which are consented under the Planning Act 2008, and to find that, one needs to go to Schedule 15 to the Environment Bill and the consequential changes that are proposed to be made through that in the Planning Act 2008. I'll deal with this quite briefly. The provisions read as being complex, but it's because they have to deal with various different scenarios in terms of the existence of national policy statements. So what it anticipates is that there will be, for various types of infrastructure and maybe at different times, what are called biodiversity gain statements. Now that is going to be a statement of government policy which sets out what should be achieved by way of biodiversity net gain for that particular type of infrastructure, and then makes provision as to how one goes about calculating that, including, for example, the pre-development value and what's counted in the post-development value, and so on. The biodiversity gain statements can exist outside of a national policy statement. So they do that in two ways. One of them is where there is a national policy statement, but it hasn't been reviewed, the relevant Secretary of State can adopt a biodiversity gain statement that says, for this type of infrastructure, I'm expecting 15% net gain, 10% net gain. I'm expecting it to be calculated in this manner. I'm expecting it to be achieved in this way. They can set that out and it can sit alongside an NPS. It doesn't trigger the review of a national policy statement for the same type of infrastructure. When a new national policy statement is designated, it can then contain the biodiversity gain statement in itself. So the biodiversity gain statement will be in the national policy statement, and when it's reviewed, it can incorporate it. And for types of development where there is no national policy statement, again, a biodiversity gain statement can be set out. So that's why the provisions read as being relatively complex, because the objective is to ensure that a biodiversity gain statement can be adopted for any type of development, whether or not it's covered by an existing NPS and whether or not that NPS is under review at the particular time. And there are then consequential changes to the determination provisions in the Planning Act 2008. So Section 104 is changed so that the biodiversity gain statement becomes a matter that is directly relevant to the determination of the application in question and a requirement to determine in accordance with it. So the statement is given prominence in the decision-making provisions, and there's provision for its adoption. I'll just go back. Just before I leave that, finally, clearly the devil is in the detail for this. The changes to the Environment Bill and Schedule 15 simply set up the architecture, the legislative architecture by which this can be delivered. And the terms of any biodiversity gain statement are a matter for the future. And clearly it is the substance that's going to be of concern to those in the industry to see how, for any particular type of NSIP or more generally, the government sets out that requirement. But we can anticipate from these provisions that we will have biodiversity gain statements should these provisions be enacted. And they will start to impose net gain obligations on infrastructure projects under the 2008 Act. A specific point on net gain, which arises in any scheme where there is compulsory acquisition of land, is whether one can justify the acquisition of land merely to deliver biodiversity net gain. I think the sort of challenge is that where there isn't a clear obligation to deliver net gain, where the obligation or the desire is expressed in the sort of terms that we've seen in the draft Energy National Policy Statement, then we don't have, we can't point to something that says, look, I need this land to make this development acceptable in planning terms and to meet the requirements of the Act and of the policy statement. Obviously, when there's a biodiversity gain statement, that's likely to be more straightforward, although there will be issues about whether you can justify the acquisition of land if you could deliver net gain by, for example, buying credits. Could you nonetheless justify the acquisition of plots for the purposes of delivering on-site or close to site net gain when you could instead achieve net gain by buying credits for biodiversity gains elsewhere? There's a sort of slight exception to this, and the Cleve Hill Solar Park DCO decision is a really good example. The examining authority said that a particular land plot, which had been included in the sort of the strategy for biodiversity gain and for biodiversity mitigation, but specifically for gain in this instance, included this land plot. The examining authority said you can't justify the acquisition of that land plot because it is only required for net gain and there's no obligation to deliver net gain. And the Secretary of State disagreed and found that that was nonetheless a compelling reason for the acquisition of land because it was part of the coherent scheme for biodiversity net gain and the overall strategy that's been put forward by the developer for that. So a useful example of where the Secretary of State has found that it is justified to acquire land for these purposes, even without that clear policy requirement to deliver net gain. So just drawing together some conclusions before I run out of time. Obviously, there's a lot more to say on all of these topics, but just a few thoughts from my perspective. First of all, if projects now anticipate a net gain requirement in the future, it might serve to protect against any risks that come about from the implementation of the biodiversity gain statement regime. Now, the provisions anticipate that these will, the biodiversity gain statement will set out when they apply. It's clear that notice will be given, that applicants will know, and they won't suddenly be faced with those sorts of obligations midway through an examination. But given the direction of travel, it seems to me to make sense for infrastructure projects to look to show how they can deliver net gain now, and indeed many of them do. And in the meantime, of course, it's a positive of the scheme to say that it can deliver net gain. It goes to any planning balance that needs to be carried out, and it may go to addressing objections, particularly from statutory consultees and from NGOs who may be concerned about the impacts of the scheme, but nonetheless be willing to recognise overall net gains as being a net positive. And I think the other point that probably requires some more thought in some projects is whether there's a sort of twin track of developing a net gain concept, which, if necessary, because of adverse findings on protected sites, could be instead treated as a compensatory measure. Clearly, one has to take extreme care about promoting net gain by reference to loss of European sites, because one still has to comply with the requirements of the Habitats Directive and the Habitats regulations now. But there is nonetheless scope for developing compensatory measures which can deliver net gain if they are not required and can meet the compensation element of the ROPE test if necessary. So those are just a few quick thoughts on this topic, as I say, much larger, but I'll hand back to Tim now.
Richard, just before we move on to Heather's talk, there's a question that Jeremy Baker has raised, and I wonder whether we might just look at that. He says, in a Secretary of State or Inspector's decision to grant a planning permission or a development consent order, what and where is the appropriate assessment document which is consulted upon with Natural England before then being adopted by the Secretary of State or Inspector as the authority?
Yeah, well, two different points, I think, on the planning permission and the DCO. There's, for a planning permission, if the Secretary of State or the Inspector is making a decision, then they will be taking the applicant's report, which will inform an appropriate assessment, and then the appropriate assessment is just in the decision letter, and one only sees the appropriate assessment in the decision letter, and only then when the Inspector remembers to put it in. But that you see it as a paragraph decision letter. The consultation then is on the applicant's report rather than on the appropriate assessment that is in the final decision. In the case of a DCO, the position is slightly different because of the publication of the examining authority's report on appropriate assessment. So they have their own report to inform the Secretary of State, which is published during the examination period and on which there will be comments from statutory consultees and others. That then goes to the Secretary of State, but the final appropriate assessment is the decision maker's decision and is included at that time, rather than there being a further round of consultation on that.
Yeah, I always find it helpful to remember that the phrase appropriate assessment is not a piece of jargon that, if you like, has a one-size-fits-all. what it means is an assessment of the impact of the scheme under consideration on nature conservation, in particular protected sites, that is appropriate to the circumstances of that particular case. And I think if people want to just follow that through, the judgment of Lord Carnwath in the Champion case is very illuminating on the conceptual and practical implications of appropriate assessment for the purposes of the habitats regulations.
Yeah.
Thank you very much indeed, Richard. We'll now move on to another topic and to Heather Sargent's talk on the Stonehenge case and assessing alternative schemes, a very topical piece of subject matter. Heather is ranked as the top-rated junior planning barrister under 35 years old, and is one of the top 5 juniors overall in the current planning law survey. She has a wide range of infrastructure experience, including advising Gatwick Airport on its proposed development consent order to bring its existing standby runway into routine use, acting as sole counsel to the acquiring authority on a compulsory purchase order for a £29.4 million road scheme. And she was one of the council team defending the judicial review challenges to the airport's national policy statement relating to the third runway at Heathrow. Heather.
Thanks, Tim, and good morning, everyone. So moving on to the first one, as will be obvious from the title of the talk, the case that I'm going to be discussing is the Queen on the application of Save Stonehenge World Heritage Site Limited against the Secretary of State for Transport, which is a decision of Mr. Justice Holgate from the 30th of July this year. It was a successful claim for judicial review of the Secretary of State's decision in November last year to grant Highways England a DCO for a new 13-kilometre route for the A303 as it runs past Stonehenge. The examining authority, by way of background, the panel, recommended that the DCO should not be granted, and amongst other things, it concluded that the scheme would result in substantial harm to heritage assets. But the Secretary of State, as you'll have gathered from the fact that the DCO was granted, disagreed with the recommendation and granted the DCO, and his conclusion on designated heritage assets was that there would be less than substantial harm. The claim was brought on 5 grounds, and Mr. Justice Holgate allowed 2 of them, allowing each of those in part, and dismissed all of the others as being, in his view, unarguable. So the DCO has been quashed, and the Secretary of State will have to redetermine the application. The first ground that succeeded was part of ground 1, which was a challenge to the Secretary of State's judgment that the harm to designated heritage assets was less than substantial and not substantial, as the panel had concluded. And that ground of challenge, if anyone's interested in looking at it further, succeeded on the basis that the Secretary of State hadn't been provided with a sufficient précis of the analysis of heritage assets that had been undertaken. But the ground that I want to focus on this morning is the second ground that succeeded in part. And if anyone does find this talk to be of particular relevance and wants to delve into it further, then in the judgment it's actually ground 5.3, so the last one, I think, to be considered by the judge. But the argument that succeeded was that the Secretary of State had failed to consider the relative merits of 2 alternative schemes. So just by way of factual context, before we get into the reasoning in the judgment, you can see here the World Heritage Site boundary. The World Heritage Site is the part that's not shaded grey, and you can see the A303, which is the road bisecting the World Heritage Site from east to west. And Stonehenge, if you can make it out, is the little red circle within the white triangle in the centre of the World Heritage Site, just to the north of the road. And then this is Highways England's diagram of the scheme, with the World Heritage Site now shown shaded pink. The new route proposed for the A303 is the red line, and you'll see that it's dotted for most of the section that passes through the World Heritage Site. That's because the proposal is to tunnel the route as it runs past Stonehenge. You can see the east and west tunnel entrances shown with a little bridge symbol, and I've set out here one of Mr. Justice Holgate's observations, which was that the panel pithily described it as the greatest physical change to the Stonehenge landscape in 6,000 years, and a change which would be permanent and irreversible, unlike a road constructed on the surface. And we'll see later how he thought wholly exceptional factual circumstances of the case led him to the conclusion that he arrived at. The debate over alternatives focused on the proposals for the western tunnel entrance, which you can see here. The claimant argued that there were two alternative schemes that the Secretary of State should have considered. So the first alternative was to cut and cover an additional 800 metres of the cutting, and the second potential alternative was to extend the tunnel so that the portals would be located beyond the western boundary of the World Heritage Site. So we'll look first at the approach that was taken by the examining authority, so by the panel, two alternatives. And I've set out firstly here, for those of you who are familiar with the National Policy Statement for National Networks, you'll know that these potential considerations are highlighted in paragraph 426 of the NPSNN, and we'll come back to that paragraph later. But the panel took the view that the applicant had correctly identified all legal and policy requirements that related to the assessment of alternatives. On the facts, they weren't concerned with the Habitats Directive or the Water Framework Directive. Flood risk policy had been satisfied and the schemes not within a national park or an AONB. So the panel's view was that the only consideration that there needed to be of alternatives was first of all, satisfaction of paragraph 427 of the NPSNN, which we'll come back to, and secondly, assessment of alternatives, of reasonable alternatives to the extent required under the EIA regulations, and thirdly, consideration of alternatives from the compulsory purchase perspective. So obviously, in view of the requirement to establish a compelling case in the public interest, there was some need to consider alternatives from that perspective. But turning on to the requirements of paragraph 427 of the NPSNN, I've set out here what that paragraph requires. Essentially, the requirement is that an options appraisal be undertaken, but importantly for the overall reasoning in the Stonehenge case, paragraph 427 says that where a full options appraisal has been undertaken as part of achieving inclusion in a road investment strategy, in a RIS, then option testing need not be considered by the examining authority or the decision maker. And the text that I've highlighted in bold reiterates that. So the only requirement, if there's been a full options appraisal as part of the RIS process, is that the examining authority and the decision maker satisfy themselves that the options appraisal has been undertaken. And you'll see that on the facts, the scheme here had been included in a RIS, and the examining authority's approach to alternatives, to be fair to the examining authority, reflects the text of paragraph 427 perfectly accurately. We then come on to paragraph 426 of the NPSNN, and obviously that paragraph is more broadly worded. It's where we find a requirement, I think an unsurprising requirement to be honest, to comply with all legal requirements and with any policy requirements that are set out in the NPS in relation to the assessment of alternatives. I haven't set out expressly all of the requirements that are identified in paragraph 426, because as I said, the only one on the facts here that was in play was the requirements of the EIA directive. But as many of you will know, and as you can see from the summary that's provided in paragraph 426, the EIA directive doesn't itself require a full-blown assessment of the comparative merits of the scheme and alternatives. Again, then on the facts, the examining authority was satisfied that the environmental statement met the requirements of the EIA regulations, and the examining authority did consider alternatives in the context of assessing whether compulsory acquisition was justified, but that didn't include consideration by the examining authority of the relative merits of the two alternatives to the proposed western cutting. We come then to the examining authority's overall conclusion on alternatives, which I've set out there. PR is the reference for the panel report, and you'll see there's heavy reliance by the examining authority on paragraph 427 and on the assessment that was undertaken for the purposes of including the scheme in the RIS. You'll also see at the bottom that the Secretary of State in turn reached the view that the impact of alternatives was neutral. He relied upon the examining authority's conclusion and saw no reason to disagree with the panel's reasoning or with its conclusion, essentially that matters in relation to alternatives had been covered off by the applicant satisfactorily. What then might wonder is unlawful about any of that or about the examining authority's approach? Well, in a nutshell, the error that's identified by Mr. Justice Holgate is, as he describes, paragraph 252 of the judgment. So the panel went wrong, in his view, in that it didn't make its own appraisal of the relative merits of the proposed scheme and the two alternatives. And he points out that that's despite the fact that the panel went on to make a number of strong criticisms of the proposed western section, and that was one of the things that led the panel to recommend refusal of the application for the DCO. In terms of what had been missed, one point that we'll see later that the judge considered to be significant was that Highways England had said in the heritage impact assessment that both of the alternatives had been rejected because they were unaffordable. We're talking about, I think, a £264 million increase in project costs for a longer section of cut and cover and a £578 million increase for the longer tunnel option. But then in the examination, Highways England additionally said that it had rejected both options, also because they would provide, in Highways England's view, minimal benefit in heritage terms. And Mr. Justice Holgate was clearly troubled by the fact that neither the examining authority nor the Secretary of State had expressed any view on whether that assertion about minimal benefit in heritage terms from either of the alternatives was actually substantiated. We come then to the legal principles that are established in the judgment, and these are really the headline points, I think, for anyone who's promoting a project in the future and trying to work out, in the light of the Stonehenge judgment, what is required by way of the assessment of alternatives. So first of all, clarity from Mr. Justice Holgate, if it wasn't apparent from the text of paragraph 426, that paragraph 426 and the requirement to comply with all legal requirements does include legal requirements that arise from judicial principles set out in the case law. The second point is that paragraph 427 doesn't override paragraph 426, and so satisfying paragraph 427 of the NPS does not excuse an applicant from meeting any additional requirements that arise from paragraph 426. You can't use paragraph 427 to circumvent obligations that come through paragraph 426, which would include, as well as EIA, habitats, and the Water Framework Directive as well. Then just looking at more detailed reasons given by Mr. Justice Holgate as to why he didn't think that the examining authority or the Secretary of State could confine themselves simply to checking whether an options assessment had been carried out in compliance with paragraph 427. First of all, he points out that there might well have been a change in circumstances since the RIS options appraisal has been carried out. And on the facts in Stonehenge, one such point was that the argument had been raised by Highways England that both of the alternatives would only result in a minimal benefit in heritage terms. And Mr. Justice Holgate, as I mentioned, was troubled by the fact that there was no view from the examining authority or the Secretary of State on that point. There's also, as he points out, the scope for a disagreement and a difference in judgment between the examining authority or the Secretary of State and the applicant. So essentially the examining authority or the Secretary of State might not agree with the analysis set out in the options testing at RIS stage. And again, on the facts, that was the case because the panel disagreed with Highways England's assessment of whether there'd be harm to the World Heritage Site. So Mr. Justice Holgate does actually go so far as to hold that it was irrational for the panel to have treated the RIS options testing as meaning that it was unnecessary for the panel then to subsequently go back and consider the relative merits of alternatives. There's then another point mentioned in the judgment, although strictly speaking, it didn't ultimately apply on the facts, but I think it's important to note for future reference. as many of you will know, where you have a scheme that would cause substantial harm to the significance of a designated heritage asset, then the NPS-NN requires the applicant to demonstrate that the substantial harm is necessary. So there's a test of necessity if you're in substantial harm territory. And you'll see from the passage that I've set out here that Mr. Justice Holgate emphasises that in those circumstances, it's not a question of simply striking an overall planning balance, because there's this necessity test. And in his view, alternatives for achieving the benefits are an obviously material consideration, so they become something that the decision maker has to take into account. So if you're promoting a scheme and either you acknowledge or indeed another party is arguing that it will cause substantial harm to the significance of a designated heritage asset, then you should do your best, I'd suggest, to ensure that the examining authority and the decision maker do go so far as to assess the relative merits of any alternative ways in which the scheme benefits could be secured. Now, on the facts here, as we've already seen, the Secretary of State, in contrast to the examining authority, concluded that there would be less than substantial harm from the western section of the scheme rather than substantial harm. But that difference in judgment between the panel and the Secretary of State wasn't enough to save the DCO. Mr. Justice Holgate, in the judgment, if anyone needs to go back and read this afterwards, it's at paragraph 278 and following. Mr. Justice Holgate sets out a lengthy list of reasons that cumulatively, and I think it is important to emphasise that it was on the basis of all of the reasons taken together cumulatively, he comes up with a list of reasons why he concludes that the relative merits of the two alternative options were an obviously material consideration, such that it was irrational for the Secretary of State not to assess those relative merits, and the Secretary of State's failure to do so was an error of law. And you'll see there that I've highlighted that Mr. Justice Holgate describes the circumstances as wholly exceptional. So for that reason, I haven't set them out in full, because many of them are, as you'd expect, specific to the unusual facts of the Stonehenge case. But what I have attempted by way of conclusion is to give some thought to what points might be relevant to future projects. And I think the most obvious takeaway from this aspect of the Stonehenge case is that paragraph 427 of the NPS-NN doesn't override paragraph 426. So I'd certainly advise against proceeding on the assumption that if you have an options appraisal that was undertaken for the purposes of achieving inclusion of your scheme in a RIS, don't assume that the examining authority and the decision maker will not need to give any additional consideration to alternatives. Don't assume that, notwithstanding what I thought was really relative, quite clearly worded text in paragraph 4.27 of the NPS-NN. But the reason that that's not a safe assumption is because obviously you have to read paragraph 427 together with the broader obligation in paragraph 426 to satisfy all other legal requirements. And those legal requirements include the Trust House Forte principles that will be familiar to many of you. I've set those out here, but essentially the position is that where there are clear planning objections to development, then it may well be relevant and indeed necessary to consider alternatives. And that's particularly so where the major argument advanced against the disadvantages of the scheme is that there's a need for the development that outweighs those disadvantages. Now, it remains the case, in my view, that the question whether, when you apply the Trust House Forte principles, you have to assess the relative merits of alternatives. So the question whether the merits of alternatives are an obviously material consideration, it's one that will continue to depend on the facts of the particular application. And in one sense, obviously, it's easy to say that the Stonehenge facts are wholly exceptional, simply because it's Stonehenge, and given the importance of that asset and the nature of the scheme that's proposed. But there are, I think, a couple of points that can be drawn from the judgment in Stonehenge that hopefully give a bit more of a pointer as to whether or not on the facts the Trust House Forte principles are likely to require an assessment of the merits of alternative proposals. First, I think it's more likely that there'll be a need to give further consideration to alternatives where circumstances have changed following any options appraisal undertaken for RIS. And that would include where a point is raised in the DCO application process that goes to the merits of the alternatives, because that's something that the examining authority and the Secretary of State are likely to need to consider. Also, as in Stonehenge, where there's disagreement from either the examining authority or the decision maker with a judgment that was reached in the RIS options appraisal process. So say, for example, it had been accepted at the RIS stage that there wouldn't be any heritage harm, but then subsequently either the examining authority or the decision maker disagrees with that and concludes that there will be heritage harm. That will clearly, I think, make it much more difficult to rely on the consideration of alternatives that took place through the RIS process. The other point to note in the Stonehenge judgment, it's not actually a new point, but where, again, as in Stonehenge, you have alternative options within the DCO application site, then the Trust House Forte principles apply with equal, if not greater force. That's the Langley Park School for Girls case, which is mentioned by Mr. Justice Holgate in the judgment. And I'm sure many of you will have come across that before. And the final point, just to note, I think, in terms of trying to apply the reasoning in Stonehenge to future cases, is that if the Trust House Forte principles do require the relative merits of alternatives to be taken into account, then it's clear from Stonehenge that it's not an answer to say that the decision maker had regard to the environmental information in the course of complying with the EIA regulations. And that is enough to have discharged the requirement to consider alternatives, because Mr. Justice Holgate points out in the judgment that complying with a requirement to take information into account doesn't, in his view, satisfy the specific obligation to actually compare the relative merits of the alternatives against the scheme that's proposed. And that's what's required. And that, in his view, is where the examining authority and the Secretary of State went wrong in Stonehenge. So that's everything I have on alternative schemes, and I'll hand back to Tim.
Thank you very much indeed, Heather. A number of people have asked if we can give the case reference number for the Trust House 40 case. I could do that. The case is called Trust House 40 Hotels Limited and the Secretary of State for the Environment. It's reported at 1987 53 Property and Compensation Reports 293. Or for those who still have the Estates Gazette Law reports, it's 1986 2 Estate Gazette Law reports at 183. You'll see from the date that it comes before the neutral citation number system came into use. So you do have to go back to one of the formal law report editions to find it. And as I recall, Heather, it was a decision of Mr. Justice Simon Brown, as he was at that time.
It was, yeah.
He was appointed, having been Treasury Devil.
Yes. Sorry, Tim. I'd also say, just in case anyone is kind of chasing up this part of the decision, it's paragraph 269 within the Stonehenge judgment, which is a helpful summary not only of Trust House Forte but also of Mount Cook, Jones, Derbyshire Dales, and the Langley Park School of Girls case that I mentioned. So paragraph 269 through to 273, 274 of the Stonehenge judgment is where to head if you need a useful summary of essentially the Trust House Forte principles and what people have said about those since.
Thank you very much. On your final point about the wholly exceptional nature of the Stonehenge case, and that is a very well made point, which everybody will appreciate. The question of the treatment of alternatives and the legal requirements is one that was raised in the debate at the public inquiry into the proposed Holocaust memorial at Victoria Tower Gardens next to the Houses of Parliament, and it was addressed in some detail by the inspector, who recommended approval of that proposal. And of course, that his reasoning and conclusions on alternatives, including the Imperial War Museum, were accepted by the Secretary of State in granting permission, or rather I should say by the Minister, the Housing Minister, in granting permission for that scheme. Some people may know that there is that we're now in the early stages of a claim to challenge the validity of the decision to grant planning permission for the Holocaust Memorial, and one of the issues raised is the question of whether the treatment of alternatives to that proposal was legally sound. So it will be interesting to see what the court makes of that, whether it's considered an arguable point in the context of the circumstances of that case, and if so, what if it goes to a substantive hearing, what the court makes of the argument on its merits. So this is a watch this space issue, I think, in the context of controversial development schemes, including but not limited to major infrastructure schemes. Thank you very much indeed, Heather. We're now going to move on to the third of our talks before we have a break. And our speaker now is Andrew Byass, who's going to speak about the Sawkill case, which was concerned with gaining entry for survey in relation to infrastructure schemes. Again, I think the Stonehenge project was the project in question. Andrew has a broad planning and public law practice. In recent years, he's been heavily involved in infrastructure policy development and challenges, acting for the Department of Transport in the preparation of the airport's national policy statement and in the challenge to that national policy statement once it was made. Also acting for the department in challenges to alleged unlawful failures to review the national network's national policy statement, about which we just heard, and also for the Department of Business, Enterprise and Industrial Strategy in respect of a similar challenge to the energy national policy statement. He was also junior counsel for National Highways, formerly the Highways Agency, in the Sawkill case. So over to you, Andrew.
Good morning, everybody, and thank you, Tim. Sawkill is a case that Tim is very familiar with as well, having acted for Mr. Sawkill. So today I'm speaking on the Sawkill case, which was concerned with the powers of entry available to those proceeding to develop nationally significant infrastructure projects. The Sawkill, as Tim mentioned, related to the proposal to construct the A303 Stonehenge tunnel and the need to undertake surveys in advance of any DCO being granted. It's a project that has plainly been a fruitful source of litigation given its controversy, but Sawkill did not depend on the particular project in issue. It was effectively blind to whether or not this was the controversial Stonehenge tunnel project or not. It's a case concerning powers of entry that are relevant to any DCO scheme which proposes inclusion of compulsory acquisition powers. And that's the reason why I've chosen to speak about it today. Since National Highways is a quasi-public organisation with a particular standing, the nature of the arguments about powers of entry for surveys and the court's findings do beg the question whether the same powers of entry as were found to be available to National Highways are available to other private entities. So I'm going to spend a little bit of time speaking first about the Sawkill case and the nature of the arguments in that case before considering the application of the findings of the judgment in Sawkill to other private bodies. The final part of my talk will then look at some of the practicalities involved in enforcing powers of entry should that become necessary. Mr. Sawkill leased some farmland very close to Stonehenge on the other side of the A303. If, like me, you're one of the people that spent many happy minutes and time enjoying the view of Stonehenge as you got stuck in a traffic jam going on along the A303 towards the West Country this summer, as you come close to Stonehenge and look to your left, you'll see the claimant's land. And it's proposed that it was proposed that the new A303 tunnel would pass through a chalk aquifer underneath or adjacent to the claimant's land and National Highways sought entry to undertake pumping tests to understand the transmissivity of the aquifer, or in layman's terms, how quickly it filled up again once it was empty. Mr. Sawkill was pretty annoyed about the prospects of these pumping tests. They would involve the extraction and discharge on his land of millions of litres of water, which he claimed would give rise to the prospect of damage to part of his land. His claim was supported by the National Farmers Union, who no doubt were alive to the fact that any ruling which made it easier for developers to gain entry to farmland would have implications up and down the country. And two issues arose. The first of those was whether National Highways, or Highways England as it then was able to rely on the powers of entry provided by Section 172 of the Housing and Planning Act 2016, which I've called the simple route, or whether National Highways was required to rely on Section 53 of the Planning Act, the less simple route, which also requires or provides for powers of entry for survey, but which first requires the Secretary of State's approval. And the second issue was confined more to the specific facts of the case, and that concerned whether the pumping tests amounted to a survey for the purposes of either of those provisions, Section 172 and or Section 53. Mr. Sawkill's argument in relation to this second argument was that while inspecting land, including boring holes in land, undoubtedly fell within the definition of survey, the act of pumping millions of litres of water on this land fell outside this concept. And his argument was that where activities which an acquiring authority wishes to undertake amount in reality to entry onto the land and the exercise of prolonged or even temporary dispossession of that land, then that activity falls outside of any notion of survey and is more properly understood as a form of expropriation, as opposed to what is legitimately understood as a survey. So fairly important rights, private rights of land ownership were an issue in the case, and the extent to which they can be interfered with by way of operation of statutory powers giving rights of entry for survey. So turning then to the two relevant provisions. The first is Section 172 of the 2016 Act, and that provides that a person authorised in writing by an acquiring authority may enter and survey or value land in connection with a proposal to acquire interest. So the authority, the authorisation is self-fulfilling. It's provided by the acquiring authority as opposed to anybody else, and it's provided to a person which could be an employee or an agent of that acquiring authority. And what an acquiring authority is defined by subsection 6, and it means a person who could be authorised to acquire compulsory of the land to which the proposal mentioned in subsection 1 relates. And those words "could be authorised" are quite important because National Highways was a person which had existing powers of compulsory acquisition, unlike other private entities that don't have existing powers of compulsory acquisition but could have such powers if they gain a DCO. And that relates to the second topic, which I'll come on to talk about. Section 53, on the other hand, requires an application first to be made to the Secretary of State. And it provides that any person duly authorised in writing by the Secretary of State may at any reasonable time enter any land for the purposes of surveying, etc., in connection with an application for an order granting development consent, the proposed application for an order granting development consent, so in advance of the application being made, or an order granting development consent that includes provision authorising the compulsory acquisition of that land. So the first issue then, Mr. Sawkill's argument was that the 2008 Act provided a complete code which governs all actions regarding applications for DCOs, such that only the survey powers in the 2008 Act were available to National Highways. He relied upon a principle of interpretation that the general words in a later statute, here the Housing and Planning Act of 2016, cannot exclude the specific provisions of an earlier statute. National Highways said no, it's simply the case that the powers overlap and that National Highways can choose between them as it sees fit. The consequence, well, legally likely little or nothing, since the survey powers in both acts are largely the same, but because of the need for authorisation under Section 53, as opposed to Section 172 from the Secretary of State, it would likely lead to delay and put landowners in a better bargaining position in terms of negotiating licenses for surveys, and potentially in respect of compulsory acquisition negotiations. Certainly, PINS at least saw the process of first applying for authorization to enter private land as important during the process of preparing to lodge a DCO application. That is perhaps not surprising given what is involved as entry to private land, and given the range of applicants and circumstances in which powers of entry for survey may be sought. And indeed, guidance issued by PINS said exactly that. The rights of entry frequently asked questions guidance said that in the case of a prospective DCO, the policy intention is that the power of entry in section 53 should be used. And the inspectorate notes the principle of statutory interpretation that where a general enactment covers a situation for which a specific provision is made by another enactment contained in an earlier act, it is presumed that the situation is intended to be continually dealt with by the specific rather than the later. So the position adopted by the planning inspectorate was very much in line with the arguments that Mr. Sawkill was making, and very much in line with the notion or the intention that specific authority should be obtained from the Secretary of State before powers of entry should be used. So Mr. Sawkill advanced several arguments. First, that the 2008 Act provided a complete code. Second, that the 2008 Act provides for supervision by the Secretary of State, which is an important procedural safeguard to prevent unnecessary intrusion upon a private landowner's property, harking back to those important private ownership rights again. And thirdly, that there are related specific powers relating to survey in the 2008 Act, which makes clear that Parliament's intention for the Section 53 procedure was for the Section 53 procedure to be relied upon. It was heard, the case was heard by Mr. Justice Dove, who rejected all of the arguments. So far as the approach that Mr. Justice Dove took, he formed the view, relying upon authority, quite rightly, that the court's task was first and foremost one of simple statutory construction. It was required to determine the meaning of section 172 and the scope of the powers it conferred by reference to the language used, their documentary and factual context, and their aim or purpose. So placing some prominence, quite rightly, on the first of those principles, that you have regard to the actual language used by Parliament and give it its natural and ordinary meaning. Principles of statutory interpretation, such as relied upon by Mr. Sawkill and which were referred to in the PINS guidance, can be a useful guide in this task, but they do not override any other consideration as a matter of principle or approach. In the particular circumstances of these provisions, Mr. Justice Dove concluded that the powers of survey in sections 172 and section 53 respectively should be understood to be overlapping powers akin to the position found in other statutory contexts in which the same conclusion, that is of simple overlapping powers, have been reached. And National Highways had relied upon the case of QC, which had reached a very similar conclusion. That is a conclusion that there were simple overlapping powers, and notwithstanding a later in time general statute, it wasn't the case that an earlier, more specific statute should be overridden. As a matter of straightforward construction, Mr. Justice Dove concluded both provisions were able to be relied upon by National Highways, including because there's no material difference between the scope of the powers of survey under the respective provisions. And insofar as the crux of the argument that Mr. Sawkill made boiled down to the greater procedural protection under section 53, given that need for the Secretary of State's approval, this was both not determinative and readily explicable. And what Mr. Justice Dove said in this regard was that the power to use section 172 of the 2016 Act has been granted by Parliament specifically to the defendant in particular in its role as an acquiring authority. It is therefore an organisation with a particular standing to which this statutory power has been granted. By contrast, he said, it is open to any individual to make an application for a DCO and to pursue it through the provisions of the 2008 Act. When that fact is borne in mind, the need for supervision by the Secretary of State in cases where the power under section 53 is invoked can be readily understood. So Mr. Justice Dove at least seems to be drawing a pretty clear distinction between those organisations with a particular standing, such as national highways, effectively those with existing powers of compulsory acquisition, in contrast to other private individuals who may not have those powers at the time they are contemplating applying for a DCO for a nationally significant infrastructure project. And it's in respect to those individuals, the need for supervision can be more readily understood. The very clear position then following Sawkill is that a body such as National Highways need not first apply to the Secretary of State for authority to enter private land for survey. It is able to directly authorise its own staff and agents to enter onto land for the purposes of undertaking surveys, so long as this is in connection with a proposal to acquire an interest in or a right over land. So very clear so far as an organisation such as National Highways is concerned. The second issue I can deal with more simply, that you'll recall related to the scope of the power to enter land to survey. The issue here with the proposed pumping tests was not the boring of the holes on the claimant's land per se, but the significant discharge of water required to see how rapidly the chalk aquifers would refill. Mr. Justice Dove concluded that while this was undoubtedly an intrusion upon possession and enjoyment, that was no different, for example, to an archaeological survey, which may involve an extensive array of trial trenches and could be equally, if not more, intrusive. Compensation is payable for loss and damage, and that, he found, was the appropriate remedy for a landowner in a position akin to Mr. Sawkill. Mr. Justice Dove's reasoning begs the question, however, referring back to the first issue, what if you are a private entity intending to apply for a DCO and you're not an organisation with a particular standing? Well, there's a potentially short and a potentially long answer. The shorter answer is that Section 172 is pretty clear. An acquiring authority means a person who could be authorised to acquire compulsory the land to which the proposal mentioned in subsection 1 relates. Any private entity could be authorised to compulsory acquire land for the purposes of a DCO. So notwithstanding the policy intention referred to in the PIN's guidance, and notwithstanding Mr. Justice Dove's comments about the understandable nature of the need for supervision by the Secretary of State, the need for prior authorisation from the Secretary of State, the clear language of Section 172 doesn't suggest of any such limitation. And it would mean that the suggestion made by Mr. Justice Dove in his judgment should not be followed. The long answer is more nuanced. And recalling that the court's task in statutory interpretation is to start with the language used, this is a powerful indication that any prospective DCO applicant can authorise one of its consultants or employees to enter onto land for the purposes of survey, so long as there is a real and meaningful proposal to compulsory acquire the land in question. Just go back a slide. But the legislative history may suggest a more restrictive approach is required to the availability of powers of entry to other private entities, even those intending to undertake nationally significant infrastructure projects. When first enacted, Section 172, the definition of acquiring authority in Section 172 bore the same meaning as that found in Section 7 of the Acquisition of Land Act 1981. The amendment of Section 172 to the present definition was consequential upon later changes to the 2016 Act, and the partial introduction of powers which provided for the temporary possession of land, and that was by Section 18 of the Neighbourhood Planning Act 2017, and related powers of entry to survey in connection with those powers for temporary possession under Section 26 of the 2017 Act. Since the previous definition was tied to the Acquisition of Land Act, a new definition was needed. Arguably then, there was no intention to broaden the scope of those able to rely upon the powers of Section 172. And such a conclusion would be supported to an extent by the explanatory memorandum to the Neighbourhood Planning Act of 2017, which says that Section 26, which extends the right to enter and survey land in Section 172 of the Housing and Planning Act by making it available in connection with a proposal to take temporary possession of land, refers to that and says a consequential amendment is also made to the definition of acquiring authority to clarify its meaning in this context. Given that the reference to the amendment being consequential upon this particular change may suggest a limit to the aim or purpose behind the present broad definition of acquiring authority in the current version of section 172, this does suggest and give some credence to an argument that Mr. Justice Dove's statement about there needing to be a private entity of some standing is correct. But whether this limit exists or was intended needs to reflect the clear language in the statute, which does not expressly at least state that section 172 is so limited. The potential problem may not be overly significant. Many NSIP developers are already bodies with a particular standing, and many private entities can be provided compulsory purchase powers under orders or directions made by the Secretary of State. For example, the granting of an electricity generation license can include powers of compulsory acquisition, and in such circumstances, this potential pitfall would be avoided. What's the best way through? Well, pending a determination from the court, the question will remain at large. If you are a private entity without existing compulsory acquisition powers, the safest route is probably the section 53 route. Private entry could alternatively be negotiated, or section 172 powers could be relied upon if necessary enforced by a warrant, or steps could be taken to gain compulsory acquisition powers, for example, through obtaining an appropriate generation license or similar. If the course of using section 172 is pursued, section 172 provides that simply provides that the route to obtaining entry is by self-authorization. The only necessary preliminary requirement to enter private land is a relevant written authorization. If a relevant landowner refuses, section 173 can bite, and that provides that a justice of the peace may issue a warrant authorizing a person to use force in the exercise of the power conferred by section 172 if satisfied that another person has prevented or is likely to prevent the exercise of that power, and that it's reasonable to use force in the exercise of that power. The application is made to the magistrate's court, where the procedural rules are not at all straightforward for this type of application, that is enforcing a warrant. Criminal Procedure Rules 47 deals with investigation orders and warrants. It's got quite detailed provisions about the sorts of warrants that are normally issued by the magistrate's courts. And paragraph 47.34 has a catch-all provision which addresses applications for warrants under any other power. If a warrant is pursued, you need to be prepared for a judge unfamiliar with the power in issue, its requirements, and the necessity for any order. The warrant issued authorises the use of such force as may be reasonably necessary to enter for surveys. That is, it authorises forcible entry onto privately owned land, so the judge will need persuading. It'll be necessary to demonstrate that there's a real proposal to acquire an interest in or a right over land, so the 2008 Act provisions and powers will require explanation, which is not an enviable task at all. It will be necessary to demonstrate that there's a real proposal, as I say, and the provisions that enable powers of compulsory acquisition of land to be included within a DCO will need to be explained, why it is that such powers would be applied for in the case in hand, and why it is that such powers could be granted by the Secretary of State in the DCO application, having regard to the infrastructure proposals in hand. Applications are made without notice to a landowner, so there's a duty of full and frank disclosure. So it's certainly worth spending the time to carefully spell out what is required and why. Thank you very much.
Thank you very much indeed, Andrew. That was both a clear and straightforward analysis of the judge's analysis in Sawkill.
The issue just didn't arise, did it, Tim? Really, when we were in Sawkill, because of the nature of Highways England as it then was.
That's right. That's right. I think Sawkill is a helpful case, even allowing for the fact that I came second in that one. But I think that the practical limitations and the questions that arise, as you say, are equally important for people in practice, and you've outlined the nature of those questions very clearly in your talk. We don't have any outstanding questions from those attending the seminar, the webinar at the moment. My inclination is firstly to ask whether Heather and Andrew have any further points, either on their own talks or on what else that we've heard this morning, that they would wish to offer at this stage. But subject to that, I think we can move to our mid-webinar break and resume a little later. But I'll just ask Heather and Andrew whether there's anything that they feel that they feel motivated to or provoked, if you like, to offer in the light of what we heard so far.
I don't know, nothing of any sort of earth-shattering revelatory significance. No. I certainly do agree with what you were saying, Tim, at the end of my presentation, that I feel that the issue of consideration of alternatives is the gift that keeps on giving, just because, you know, there's numerous different statutory regimes that require just, you know, consideration of alternatives in some form or another, and in different forms and to different extents. So I'm particularly, you know, the discussion in Stonehenge about the fact that looking at alternatives for the purposes of EIA isn't enough to get you home, I think is an interest and an important point that may have not been obvious, certainly to many. But to be honest, reconciling the different obligations and all their extents and things, I think is potentially difficult, particularly because, you know, Trust House Forte, I think you can only ever reach a conclusion on that on the specific facts of the case. So the interaction between the various statutory regimes and, you know, those principles is potentially quite complex.
Yes, I think you're absolutely right. What ultimately must guide the question in the case of any given major scheme as to how far, if at all, it's necessary to develop consideration and evaluation of alternatives as part of the decision-making process, whether on the part of the applicant or indeed in the examining authority's own evaluation of the merits of the scheme, seems to me to be again, and perhaps self-evidently, but nevertheless it's important to say, a case-specific question. Stonehenge is you can't imagine a more valuable historic asset than Stonehenge and its setting. The development of the alternative scheme at Stonehenge was quite detailed, and it was a central part of the case of those opposing the scheme that was before the examining authority, to say that there was an alternative which was feasible and which had real prospects of delivering the benefits that the Stonehenge project was seeking to found upon, with a lesser degree of risk to the historic asset. So the position was very clear cut there. What you find from what Simon Brown acknowledges in Trust House Forte is that is by no means going to be the case in many, and perhaps even most, situations where the question of alternatives is invoked. There's always a balance to be struck between the degree and urgency of the need for the project, what it is that it's seeking to address and to provide in the public interest, the degree of harm and the extent of harm that necessarily will flow from meeting that need, and the degree to which there is a mature and developed understanding of the performance of alternatives. Now, the latter, of course, is where the difficulty of judgment arises, because necessarily the promoter will have focused more effort on the detailed evaluation of its own scheme than it will on alternatives. And generally speaking, the resources available to objectors will be much less, so they will not have generally have had the opportunity or the wherewithal to bring forward, if you like, a fully evaluated appraisal of the alternative that they rely upon. So there's always a margin of uncertainty as to quite what the risk is, given the relative the imbalance, if you like, between the appraisal of the scheme as the scheme that's being advanced and the alternative that is being set against it. But I think that's one of the factors that underlies the case law on this question, and I think Simon Brown had in mind in Trust House 40, that you have to allow the fact that that unless you get that balance right, you run the risk of almost always knocking down the scheme that is under consideration, because it is going to have an adverse effect. That is inescapable. And if you say, well, we better go away and have a better look at the alternatives put forward, you end up with a situation where, as a matter of logic, you never actually get to a decisive point in whether or not the given scheme should proceed. I think that in Stonehenge, Mr. Justice Holgate made what, to my mind, is a pretty compelling explanation, analysis as to why he thought that that issue, that point hadn't yet been reached in Stonehenge. It'll be interesting to see whether, as I said earlier, the court, if it's asked to consider it in detail, reaches the same conclusion on the Holocaust Museum case, because one of the key points relied upon by the inspector and the Secretary of State in that case in deciding to grant permission in the face of the asserted claims of a site adjacent to the Imperial War Museum was that that there was an obvious and manifest urgency in getting the Holocaust Museum built, so that survivors of the Holocaust could actually, if you like, could benefit from the presence of that facility as a mark of the United Kingdom's recognition of the unique wickedness of the Holocaust. And that it's the passage of so many years since the Second World War, it was the time left to enable survivors to have that to enjoy that benefit. That's the right way of putting it. Was very short, and so if one was to delay realizing a scheme that was otherwise seen as acceptable, albeit it had impacts on heritage assets, that one was running the grave risk of failing to fulfill the public interest. That was the logic of the Secretary of State and Inspector's position. Of course, the question for the court will be whether that logic is sound in the face of the counterclaims that the objectors will put forward to say, well, the Imperial War Museum could be brought forward, but by definition, it hadn't received the same degree of development because it wasn't the scheme that the promoters of the scheme at Victoria Tower Gardens had been able to devote to it. So that is, I think, an interesting underlying question, which I think the courts have been alive to in the key cases that have come forward, beginning, I think, with Trust House 40, and then many of the cases on motorway service areas and so on and so forth over the years since then.
I think the potential difficulty is that both Stonehenge and obviously the Holocaust Memorial as well are unique, sort of very obviously distinctive cases, and I think the difficulty is really knowing what the sort of prospects are of being required to undertake a more developed assessment of alternatives on a case that isn't as sort of factually distinct and unique as either of those proposals. So what's the risk really in relation to a sort of more bog standard DCO application. And I think it's difficult. It is difficult to take that much from Stonehenge, except that, you know, I don't think it's safe necessarily to just sort of straightforwardly rely on paragraph 427. But yeah, you're right, Tim. I mean, most of the entries in Mr. Justice Holgate's list of reasons are to do with the value, the heritage value of the site, and the nature of the works. And then there was the point as well, which he does emphasise several times, about what I think he saw as the new argument over the respective sort of heritage impact of the alternatives that hadn't been considered. So where those factors are absent, which they probably will, you know, they will be in other cases, it's more difficult to know where you're going to end up, I think.
Yeah. We've got a question from Charles Clark, which perhaps is more for Andrew. Charles asks, do you have a feel for how PINS and the department have received the Sawkill case outcome? Controls over surveys involving DCOs now in the main fallen outside the control of PINS and the Secretary of State if Section 53 is not used.
I saw the question, Tim, and I think I agree with the observation that Charles has made, that the control has fallen outside of the Secretary of State if Section 53 is not used. So far as any reaction is concerned, well, the PINS guidance that was referred to in Sawkill is still on the PINS website. I looked at it yesterday, and it's still there saying the same thing, still saying the policy intention is that Section 53 should be used. So I think that's still the aspiration, but I'm not aware of any attempts that have been made to limit the application of Section 172 to bodies without some particular standing. I was involved in a case that effectively settled on the doorsteps of the court, where this issue was going to be argued out in front of Mr. Justice Holgate. But in that case, the DCO applicant did acquire powers of compulsory acquisition through a generation license, and so the issue fell away. They got the warrant when, on my client's case, Section 172 didn't assist them. But by the time we got to court, Section 172 did, because by that stage they had powers of compulsory acquisition. So it's an issue potentially still at large, but I've not seen anything from the department to suggest that they are concerned about where Sawkill has landed and the lack of control they have. Yeah.
Somebody's asked me whether the HS2 promoter had powers of access onto land until the HS2 legislation was passed. I think the answer to that is yes. That was the position, because powers of the HS2 promoter, or more specifically the nominated undertaker, that is to say the undertaker who was nominated by the Secretary of State to carry out the works to construct phase 1 of HS2, that person's powers derived from the relevant provisions of the 2017 Act itself, and HS2 Limited, which is the nominated undertaker for that purpose, wasn't a body that was able to rely upon pre-existing rights of entry under the Planning Acts or any other, or the Highways Act or other legislation, because it wasn't one of the bodies on whom those powers of entry were conferred under those pre-existing public and general acts. So that was the reason why, prior to the enactment of the 2017 Act and the powers of entry conferred upon the nominated undertaker by that act for the purposes of the HS2 railway, that was why the matter had to be dealt with by agreement between the landowners and HS2 Limited, which obviously presented, from HS2 Limited's perspective, some difficulties now overcome, because they do have powers of entry when they feel they need to use them. There's a just before we finish, we'll deal with one other matter, which is rather say before we break, which is to do with again to do with the right to propose an alternative under the DCO process. Mark Sullivan says that appears to be limited or even blocked compared with the right of objectors in Schedule 1 of the Highways Act 1980 to a proposed alternative route for a trunk road or special road at a public inquiry. I think, Heather, the position is that the DCO process certainly enables opponents to the project to bring forward what they say is a better alternative to realize the need which the DCO project is designed to achieve, and to have that alternative appraised and evaluated on a comparative basis by the examining authority and the Secretary of State. And indeed, if it's an alternative that has any legs, it ought to be dealt with as part of the environmental assessment as well, shouldn't it?
Yeah, I think that's right. I mean, I think the difficulty with the EIA regs is it does leave the sort of choice as to what alternatives to look at in the applicant's hands. But certainly, even if you couldn't make out an argument that it ought to have been looked at as part of the EIA process, it is clear from Stonehenge that if you can succeed in making enough of a case that, you know, it's so obviously material that it's something that the decision maker needs to assess, then you'll get home. You know, that's the threshold, is can you engage the Just House Forte principles and make it, you know, obviously material so that it's irrational for the decision maker not to think about it, which isn't, of course, as you said earlier, Tim, it's not, of course, to say that, you know, all that is required is an assessment of the relative merits of the alternatives. It's not a kind of showstopper necessarily, but it is the case that if it's sufficiently obviously material, if that threshold is passed, then the relative merits of the proposal will have to be considered. Yeah.
I'm going to, I noticed there is a further question from Robert Gillespie, but I think given that we've now reached just before 22:12, I think we will have our break, and I'm sure we can answer Robert's question another way. So we'll break now and we'll resume at just after noon. So as I say, two minutes past 12, and we'll resume with the second half of this seminar. We'll look forward to seeing you then. Thank you. Welcome back, everybody. We'll now resume and deal with the second part of this webinar in relation to recent developments in regard to infrastructure development. I'm now going to present a short talk on the issue of climate change after Plan B. It occurred to me that perhaps not everybody knew what is meant by Plan B. What I refer to, of course, is the major judicial review litigation in relation to the National Policy Statement for Airports and Heathrow Airport, the third runway. The reference is to the Supreme Court decision in the case of the Queen against the Queen on behalf of Friends of the Earth and Heathrow Airport Limited, 2020 UK Supreme Court 52, and that was the appeal by Heathrow Airport Limited to the Supreme Court from the decision of the Court of Appeal, which quashed the air transport national policy statement in relation to matters relating to climate change and the Paris Agreement. So if we move to the first slide, and some perspectives on climate change. Climate change, of course, is a matter that a topic that arises on a number of different perspectives and a number of different levels. There is obviously the political, and that is the environmental, economic and social challenge of global warming. Then there is the legal, that is in UK statutory provisions, but primarily focused on the provisions of the Climate Change Act 2008. And I also draw attention to the Net Zero Target Amendment Order of 2019. Then there is the perspective of government policy, and I've referred to the Clean Air Strategy Then there is the international perspective in terms of treaty commitments, and of course the Paris Agreement is the relevant example of that perspective for purposes of this talk. Then there is the question of need assessment for major projects and the function of climate change considerations as part of that process. That is to say, the preparation and adoption of national policy statements under the Planning Act 2008. And then there's the question of authorization of major projects through the development consent order process, so sorry, I've just realized my video was not on. There we are. Development consent order process, and of course that is a process that is very much in the future so far as Heathrow is concerned. Turning then to the next slide, and focusing first of all on the legal response to climate change. I mentioned the Climate Change Act. That act set up the Committee on Climate Change, a advisory body advising government on the UK's strategy and performance in meeting climate change objectives and climate change targets, chaired, as many of you will know, by Lord Deben, formerly John Selwyn Gummer, Minister in the John Major administration in the 1990s. There is the mandatory target for UK carbon change. I've mentioned the 2019 order. The net zero target is the current target, which is enshrined in national law. Then there is the provision for establishing periodic carbon budgets to cap United Kingdom carbon emissions in a series of 5-year periods. We've had at least 3 of those periods elapse since the Act came into force, and they will continue to be a feature of UK strategy for meeting the challenge of climate change in years to come. I've mentioned the advisory role of the Climate Change Committee. The objective under the Act is to move progressively towards the 2050 target, and Section 10 sets out a series of statutory considerations such as economic circumstances, the state of United Kingdom technology, and other matters that are relevant to the setting of carbon budgets and carbon accounting under the Act, and are central to the advice that is given by the Climate Change Committee to government in accordance with its statutory function. And then in terms of parliamentary scrutiny, carbon budgets are laid before Parliament, and the government is required to annually to make a statement, an emissions statement, and to lay that before Parliament for Parliament's consideration. The next slide, it turns to the question of policy response to climate change. The Clean Air Strategy, I think I'm right in saying the most recent incarnation, 2019, sets out the government's policy for decarbonising the national economy. It sets out proposals for spreading decarbonisation through the economy with a series of illustrative pathways. It's not prescriptive. It identifies means of managing emissions. I've identified some of those, but by no means all of them, through taxation, through technological innovation, through the implementation of a national emissions trading scheme. It's important to note that it's for government to choose how emissions from major infrastructure projects should be managed and controlled within its overall strategy for achieving the statutory 2050 net zero target. And then turning to the next slide, we're move to the field of international obligations, the UK government's treaty commitments. It's of course in this context that the Paris Agreement sits. The signatory parties agreed to prepare, communicate and maintain successive nationally determined contributions, NDCs, that they intended to achieve, and to pursue domestic measures to achieve those NDCs. And obviously the Climate Change Act is central to that process. There was no obligation on parties to adopt binding domestic targets to ensure that their stated nationally determined contributions were met. Paris set a global target to hold global average temperatures to well below 2% above pre-industrial levels, and to pursue efforts to limit temperature increases to 1.5% above those levels. And there was a longer term commitment as part of signatory parties treaty commitments to achieve a long-term balance between emissions and their removal. What then did governments say about Paris? We turn to the next slide, and ministerial statements in the House on Paris. Two were considered by the courts in the Heathrow Airport litigation, both made in Parliament at the dispatch box before the government had formally ratified the Paris Agreement. And what was said was, in substance, that it was necessary to enshrine the Paris goal of net zero emissions into United Kingdom law. The question, ministers said, was for government was not whether that was done, but how we do it. Following ratification by the UK government of the Paris Agreement, the Committee for Climate Change advised that the then current statutory carbon reduction target did not require to be changed. And that was the context in which the draft airport's national policy statement was promulgated. And in drafting that document and in consulting on it and the associated appraisal of sustainability, the Secretary of State took account of existing carbon reduction targets and the advice of the Climate Change Committee as the statutory advisory body on climate change. And as many of you will know, the policy statement was adopted in June 2018. We go on to the next slide. That then sets the context for the issue which was raised before the Supreme Court, which was in these terms: did the ministerial statements on the Paris Agreement and the United Kingdom response show that the Paris Agreement was, quote, government policy for the purposes of the preparation of the NPS under the 2008 Planning Act? The Court of Appeal held that this was indeed the case, and that the Secretary of State had failed to explain how the national policy statement took account of government policy, committing to implementing emissions reduction targets in the Paris Agreement. Heathrow Airport Limited appealed and challenged that analysis as based on a misconception of what constitutes, quote, government policy in the context of the Planning Act 2008 and the process of preparing the national policy statement. And then to the next slide, we see the Supreme Court's reaction to that issue. The key paragraphs are to be found in paragraphs 105 to 108 of the Supreme Court's judgment. And what they said was that it was necessary to adopt a purposive approach to what was meant by the phrase government policy, an approach that was rooted in the statutory context in which that question arose. In the present case, in the context of the statutory regime for the preparation of national policy statements in respect of nationally significant infrastructure projects, the relevant statutory purpose is to ensure a degree of coherence between policy as set out in the National Policy Statement under preparation and established government policies relating to mitigation of and adaptation to climate change. That meant that referred to policies which have been cleared by the relevant government departments on a government-wide basis, what we know as informally as the right round approach to policy development and policy adoption at government level. And the Court of Appeal contrasted that with the approach adopted by the Supreme Court contrasted that with the approach adopted by the Court of Appeal and advocated by the respondents, Friends of the Earth and Plan B and so forth, which, if adopted, said the Supreme Court, would create what they characterized as a bear trap. They said that Parliament cannot have intended to create a bear trap for ministers by requiring them to take into account any ministerial statement which could, as a matter of ordinary language, be described as a statement of policy relating to the relevant field. Obviously, as a matter of ordinary language, what Andrea Leadsom and Amber Rudd had said in Parliament at the dispatch box could be seen as, could be characterized as a statement of government policy. But it wasn't within the scope of government policy for the purpose of the statutory context in which the issue arose in the appeal, that is to say, in relation to Section 5 of the Planning Act 2008. And what the Supreme Court had it well in mind is the practical difficulties and risks of the approach, which the misconceived approach to that question, in which they saw the Court of Appeal as having given. As Lord Hodge and Lord Sales put it in their joint judgment, otherwise civil servants would have to trawl through press statements and would have to trawl through Hansard in order to identify something that appeared to be government policy in the broader sense of ordinary language, and that process was not one that was envisaged and was correct in law. They drew an analogy with the established principles of legitimate expectation and said that at the very least, for a statement by a minister to pass muster as government policy in this context, it would need to be something that could be analysed as being reliable under the law of applying the principles of legitimate expectation. You'll see that analysis in paragraph 106 of the Supreme Court's judgment. And they offered what they described as an epitome of the concept of government policy in this context, a formal written statement of established policy. Most obvious example being the National Planning Policy Framework. So to the next slide, what then of the Paris Agreement and ministerial statements about it? Those ministerial statements were not government policy as the court had construed it. I've mentioned the practical issues that would arise if that were not the case in relation to trawling through Hansard and so forth. The Paris Agreement itself was not government policy, and the ratification of the treaty was an act on the international plane rather than giving rise to direct domestic legal obligations. They drew attention to the Gina Miller case and the decision of the Supreme Court in that litigation regarding Brexit, United Kingdom's obligations in international law are one thing, but they are not part of United Kingdom law and give rise to no legal rights or obligations in domestic law. A treaty obligation, to the contrary, requires domestic law making steps which are uncertain and unspecified at the time of ratification of the treaty. So, a treaty obligation and the commitments given at international level are often question begging in important respects, and those questions are only answered as and when and if those treaty obligations are realized either wholly or in part through national legislation, which is subject to scrutiny by Parliament. So we come to the next slide. What then are the consequences of the Supreme Court's approach? The first is, going back to the beginning of my talk, the legal and policy arrangements on climate change under the 2008 Act and government policy statements such as the Clean Air Strategy provide a clear strategy for meeting carbon budgets and achieving the net zero target by 2050. That's a national strategy of which government is committed to pursuing, and upon which it has advice from the Climate Change Committee, and if you like, the roadmap through to achieving it is set out in legal terms and in terms of legal obligations under the terms of the Climate Change Act. The government has a good deal of latitude in the action it takes to attain those objectives as part of an economy-wide transition, so embracing major infrastructure projects, but by no means limited to them. The likely emissions resulting from the construction and operation of major infrastructure projects are to be considered under that statutory and policy framework. And it's government which is responsible for the policy choices on how to manage the impact of such projects as part of that transition. That's not a matter which is of under direct control and decision by the courts. And those points emerge from the litigation brought by the broadcaster and environmentalist Chris Packham, seeking to challenge the decision to give the green light to the HS2 rail programme in February of last year in a case called Packham and the Secretary of State and the Prime Minister, which is 2020 EWCA Civ 1004, where the Court of Appeal rejected in some respects a similar argument by Mr. Packham against the decision to proceed with HS2, founded upon an alleged failure to have proper regard to the UK's commitments under the Paris Agreement. You'll see that the points I've made are reflected in the court's reasoning in paragraph 87 of that judgment. So the focus it should be on the project under consideration and its performance in terms of the economy-wide transition, the contribution it makes towards that, the challenges that it creates in achieving that transition. And I suggest that the message from the Supreme Court's decision is to leave the grand gestures to the political sphere rather than to seek to persuade the court to enter into that arena. Now, of course, none of that detracts from the importance of assessing and addressing the impact of proposed infrastructure project in hand on climate change and in evaluating its carbon footprint and its impact. The need for appropriate management and mitigation measures to limit and, if necessary, offset those impacts remains both during construction and operation of the project. During construction, matters such as the management of construction traffic, low carbon construction techniques, and the impact of construction on the natural environment and people, air quality, biodiversity, flood risk, and water management are key elements of the climate change assessment and measures introduced into the project to address that. During the operational phase, the contribution that the operational project will make to the management of UK emissions and their reduction over time, both leading up to the 2050 net zero target, but also in the longer term, depending on the design life of the project, are critical considerations which need to be assessed. And the opportunity that the project offers to move away from fossil fuel energy sources towards green sources is obviously vital. For example, in the case of rail projects, which draw their operational power from electricity, and renewable energy schemes which are designed to replace fossil fuel energy production with renewable sources. Managing the impact on climate change in the operational phase is also important. We heard earlier about net gain and the seeking to give back to the natural environment through the development or operation of projects of this kind. And obviously a topical matter is the impact of climate change on flooding. So flood risk and water management throughout the operation of the project will be an important consideration. How these matters are to be achieved in practice, whether in terms of the need for land to enable them to be achieved, or powers under the order to enable them to be achieved, is also a critical consideration. Richard Turney touched upon the degree to which a compelling case could be made for compulsory acquisition to realise net gain proposals. But there's a broader question in relation to the impact of infrastructure projects on climate change, as to whether, in order to address and to properly manage the impact of those projects on the UK's climate change objectives and targets, it's necessary for land and powers to be sought in relation to the project in question, so as to ensure that its impact during construction operation is properly managed, and any measures to offset that impact can be achieved within the powers which will be conferred by the order if the scheme is allowed to go ahead. That brings us back to the Supreme Court's reasoning in the case to which I've been giving some consideration, because the Supreme Court reinforces the point that the focus of law and policy is on a national drive towards reducing this country's carbon footprint, to achieving the targets set both towards 2050 and in the longer term. And the evaluation of infrastructure projects forms part of that process, rather than sitting apart from it. And it should be, and infrastructure projects need to be assessed within that context and from that perspective, rather than the other way around. That is really the message of the Supreme Court's decision in the Friends of the Earth / Plan B case. Thank you very much indeed. That concludes my talk. What we will do now is to, there are one or two questions, but we'll deal with those later when we've heard from our remaining speakers, the first of whom is Jacqueline Lean. Jacqueline Lean is again, will be known to many of you. She has a great deal of experience of planning and of infrastructure projects. She has been working for a number of years closely on the HS2 high-speed rail programme. She was part of the council team which acted for the government in the Supreme Court litigation on the high-speed rail programme in 2013-2014. She has been a member of the council team promoting the HS2 legislation, both at phase 1 and phase 2A of that project. She has advised and acted in a number of the legal challenges that have occurred in relation to that project since that date. But her work on infrastructure planning is by no means confined to HS2, and she has acted for Network Rail and in relation to other infrastructure providers over the course of her practice in recent years. So with that introduction, over to Jacqueline. She's going to talk to us about implementation and delivery and identify some current issues in that context.
Thank you very much, Tim. Yes, as Tim said, I'm going to do a brief overview for the next 20 minutes or so on a few issues that have been floating around to do with the implementation and the delivery stage over the last few years. Broadly, it's three categories of things that I was going to talk about today. The first is public rights of way. The second is issues where there are changes to the consented scheme or there's developments during detailed design. And the third is touching on the ever thorny issue of actions seeking to prevent scheme implementation on the part of those who continue to resist the principle of a project. As the talk goes on, it may become a bit apparent it's been a bit HS2 heavy, but that is because a lot of the litigation, certainly over the last 18 months or so, has come up in that arena. But I do touch more generally, particularly in the public rights of way issue, on some wider points of application. So it's not just an HS2 fest, although there's a few HS2 cases kicking around at the end. So the first point I wanted to pick up on was public rights of way, and this is very much a delivery issue, but it's a delivery issue that can be assisted by some early thinking and putting measures in place during the consenting process to avoid some of these problems arising. For context, obviously, when dealing with an infrastructure project, particularly if it's a linear transport project, there's often going to be an interface with public rights of way or private means of access, which need to be dealt with so that the scheme can go forward. And often that will be through a diversion. Sometimes it will just be through a straight extinguishment or a creation of a new right or access point somewhere else. I'm touching particularly on diversions because of how that tends to operate within the legislative framework, and that's quite often where the issues I've been seeing really come up. So I've set out there, people would no doubt be familiar with the provision in section 5.6 of the Transport and Works Act 1992, which essentially says that the Secretary of State shall not, through an order under section 103 of the Act, shall not extinguish any public right of way over land unless the Secretary of State is satisfied either that an alternative right of way has been or will be provided, or that the provision of an alternative right of way is not required. And there's a provision in materially the same terms in section 136 of the Planning Act 2008 in the DCO context. And just for completeness, you can see the provisions that are in place in Schedule 4 of the High Speed Rail London to West Midlands Act 2017. It's a Phase 1 Act, which set out the schedule and the form that will be quite familiar to those who've seen this in Transport Work Act orders, for example, which essentially says this was what can be diverted or stopped up, this is what's to be provided, and will often describe it by reference to P points shown on the plan, or by description of what is to be provided for in lieu of that which is to be stopped up. And as I said below, that the consent, so the order, will often provide that the highway may not be stopped up or the rights will not be extinguished until the substitute has been provided. Sometimes it goes further and says until it's been certified, or until X, Y, or Z, or until there's been a notice which has been displayed for a certain number of days. But the principle is the same. You don't extinguish the old until the new is in place. And often will provide as well that the highway, whatever it may be, is to be completed to the reasonable satisfaction of the Highways Authority. And again, sometimes in the consents, there'll be something specific that they'll provide for a certification procedure, but often it's just left in those sort of terms. Now, there's sort of three issues that I've seen in practice over the last couple of years that arise in this context when you get to implementation and delivery, and they're being increasingly talked about in the schemes that I'm seeing as part of the consenting process. First, which is a pure implementation delivery point, if I could put it in these terms, is that it's important to bear in mind that the powers in these orders to extinguish a public right of way where a new public right of way is provided, it isn't a freestanding power. It's not as long as you provide a new public right of way, the old one is extinguished. The orders are often quite specific about what it is that's been provided. As I said, it may be that it says a route of way approximately X meters between point P1096 and P1087, or it'll be shown on a specific right of way plan that is to be provided as shown on right of way plan C plan B, something like that. So the extinguishment is affected by providing the substitute that's provided for through the consent. It's not enough that there is a new public right of way in somewhere there. The second point that can arise is that often the consent, or during the consenting process, the information that's put forward at that stage of the project just doesn't include the sort of level of detail that the local highway authority requires to then go on, or to subsequently go on and make a modification order in respect of the definitive map and statement under Section 53 of the Act. And that is something that I've certainly been increasingly seeing in terms of consents affecting public rights of way. There's an issue being raised through the consenting process. We haven't got enough information, we haven't got enough detail, and the order doesn't specify that detail. How are we going to get that information so that we can then go on and make the order at a later stage? And the third point is that often a consent may not provide what's to happen in the event of a dispute between the nominated undertaker, the developer, and the local highway authority. So it is to be completed to the reasonable satisfaction of the local highway authority. Local highway authority says, well, it's not. What happens then? How do you deal with that situation? So I'm going to touch on each of those in turn over the next few slides. This slide 3, changes to the proposed new public rights of way. This is really about what happens where you've got a substitute that's identified in your consent or on your plans, but when you get on the ground, it seems apparent that something different would work better, or you end up, or something different ends up being built, perhaps without realizing that it doesn't actually accord with what's shown on the plans. And there's a couple of issues here. It seems to be, the first is that, you know, a query may arise, well, there's limits of deviation, there's this general power in this order that says we can do prescribed works within the limits of deviation, and works to bridle ways or access ways may be specified as a work. I mean, my view is certainly that I just don't think that general power gets you out of a situation where the schedule says this shall be extinguished upon the provision of this other substitute, if you've got that degree of specificity, or if you have the particular provisions in the order that say about how the public rights of way are to be created or extinguished. So although there's obviously going to, in practical terms, be a little bit of flexibility in terms of, particularly where plans are, say, indicative only, it's unlikely that you could rely on an LOD power or the LOD provisions to put the public right of way somewhere completely different people with different people in starting entry points, or a fundamentally different route, or a much longer route, for example. So that needs to be borne in mind. And the relevance of that is, even if you've built something, or you're going to build something, which is meant to be a new public right of way, if that doesn't accord with what's provided for by the order, then it won't be effective to extinguish the existing public rights of way, and may not be effective to sort of dedicate the new one, depending on exactly what power's been relied on, or what powers you have in respect of that piece of land on which the new public right of way or the diverted public right of way is to be provided. So again, I suppose the starting point here is the importance of making sure that what gets put on the ground actually accords with what's been consented through the order, because of the difficulties that can then arise. Because if what's been provided, or is proposed to be provided, doesn't tally up with what's been put in the consent, then I suppose in legal terms, to make sure this works, there's going to have to be some mechanism for sorting that out. I mean, there's a couple of ways of looking at this, where this has happened or where it's about to happen. One is obviously if you're in the DCO context, there are the provisions in Schedule 6 of the 2008 Act, which allow the potential to apply for non-material amendments. But obviously that may be excessive depending on what change or how many changes you might be looking at. And secondly, it's also going to be in the discretion of the Secretary of State, and it may be that depending on the nature of the scheme, or depending on exactly what's proposed, it's it's not seen as being something that would be appropriate to do that way, particularly if it's been controversial, particularly if it may then affect different landowners, different land parcels. So not necessarily get out of jail free card, but potentially a provision to look at if, for example, there may be a number of small changes that need to be made that have been identified as detailed design process has gone through. But secondly, it may be that the way this just has to be dealt with is using the various powers that there are in the Highways Act 1980 to deal with things like diversion of footpaths, or the stopping up of footpaths, or the creation of new public rights of way. I mean, whilst those mechanisms are there, obviously it's not necessarily ideal to have to then rely on those, because they do carry with them their own statutory tests and considerations to be applied in deciding whether or not an order can be made under those provisions, or can be approved by the Secretary of State under those provisions. So just by way of example, if you're looking at a diversion of footpaths or bridleways or restricted byways under section 119 of the Highways Act, the test for doing that for the council to make an order is whether it's expedient in the interests of the owner, lessee or occupier of the land crossed by the paths or way that the route be diverted. But when it goes to the Secretary of State for confirmation, particularly there's been objections to it, the Secretary of State is not just looking at the expediency test, they've also got to look at whether or not the path or way will be substantially less convenient for the public, having regard to a number of matters, including the effect that the diversion will have on the public enjoyment of the path as a whole. So there are these additional merits points that come in that need to be looked at. It's not enough just to say, well, this has been done for this scheme. It's necessary for the scheme. You do have the sort of the statutory hoops to jump through if you want to use those provisions. And similarly, when you get into stopping up a footpath and bridleways, the test there is whether or not it's expedient that the way should be stopped up because it's not needed for public use. And relevant factors will be if you are applying for a diversion order to go alongside it that's being progressed concurrently, or if you're looking at a public path creation order that's being progressed concurrently. But again, there are just these additional processes and these additional hurdles that will need to be gone through to try and regularise any discrepancies that may have come up during the implementation process. And again, you know, complications may just come into that depending on the basis on which somebody has gone onto the land to create the new public right of way. Has this been a compulsory acquisition? Are there the rights to dedicate on the part of the nominated undertaker, say, or is it something that was done under powers that was relying on the order to authorise the creation, the dedication, the stopping up? So again, it's just one of those things that there are means of dealing with it, but it's not entirely straightforward these are points that are not entirely straightforward to deal with. If the discrepancies have come during the building of the new public rights of way, if I could put it in those terms, which may not then enjoy the status that would have been conferred if they've been built in accordance with the order. Moving on briefly to recording changes on the definitive map and statement. As I mentioned earlier, something I'm increasingly seeing as a concern from local highway authorities during progress of consents and afterwards is, well, there is quite specific guidance to us as an order making authority under the 1981 Act as to what we are meant to put in these documents and the information that has to go on the definitive map and statement. How do I get that information? And at times people say, well, there'll be a request that the consent or the order be modified to include that. That's usually resisted by those promoting such orders because, you know, it's the in-principle diversion, more detailed work has to be done. It'll be left over to certification. But you can have a highway authority then going, well, how do I make sure I get this information? And I'm not left with a new public right of way and I haven't got the detail and I haven't got a means of compelling the provision of that information, and I've got to somehow find it and take this forward with the costs and resource implications that can involve. So that's the expansion of the second issue. I am going to come on to a practical solution on slide 7, but it all sort of involves up all the points together. And the third is the point that I just touched on there earlier, was about disputes between the highway authority and the promoter or the nominated undertaker. A lot of the orders and consents I've seen don't make provision for dispute resolution if the local highway authority isn't content or it doesn't consider it's been provided to its reasonable satisfaction. I've seen then applications where deeming provisions have been written in. The nominated undertaker shall provide to, shall notify the local highway authority. When it's been completed, the local highway authority shall thereafter reply, and if a reply isn't received, either approving or disapproving, within 28 days it will be deemed to be accepted or certified. And that certainly has met with some resistance, as far as I've seen, during the consenting process from local highway authorities, often linked to the information point, often linked to the, well, what if we suddenly get inundated with 40 applications for new public rights of way, and we've got 28 days to determine all of them, and we've never seen any of the detail of it. How do we deal with that? We don't like that deeming provision. And I've said that could particularly be an issue where the consent may be established as the principle, but during the consenting process, weight has been placed on where people are objecting to it, say, by saying, well, it's fine because the local highway authority will have control of it, they'll have to sign off on it. So how can this be dealt with? I think the most obvious practical solution, or the most feasible practical solution that I've seen over the last few years is unfortunately sort of essentially side agreements or legal agreements that are worked up between the promoter, the applicant, and the local highway authority during the consenting process, i.e. before perhaps an objection having been lodged to protect the local highway authority's position, and then an agreement being worked out as a condition of withdrawing certain in-principle objections to the order or specific proposed modifications to the order. And there are a number of benefits, obviously, to such an agreement. I've sort of set them out there, but in summary, a key point is it can provide a process. It can set out a process by which the certification is to happen. And that can include, for example, perhaps a stage where before spades go in the ground, this information will be provided to the local highway authority. So they're aware of what the proposed route is, or the exact surfacing, or the particular width of the route, or how exactly it's going to deal with a particular obstacle before it's built, with a view to sort of reducing any problems that may come at the certification stage if it's built in accordance with those previously approved, I use that in non-formal language, plans. It can also provide, the side agreement can also provide the information that the local highway authority requires the nominated undertaker or the promoter or the applicant to provide it with when the way is certified, or in order for the way to be certified, which can then be used to make the modification to the definitive map and statement. So avoiding that situation of the local highway authority going at the end, well, apparently it's been completed, but could we have the details, please? And it can also put a provision in there for a dispute resolution procedure if there are issues between the local highway authority and the person implementing the scheme, and it can make provision for legal expenses or costs incurred by the local highway authority in connection with dealing with those approvals and certification processes. So that is quite a hot topic issue that I've been seeing quite a lot of over the last few years, and this seems to be a practical way of dealing with it. But again, it's one of those things that needs to be thought about during the consenting process, because that's really the opportunity where local highway authorities can use an objection or use proposed modification to the order in order to secure this sort of protection going forward. Moving on, again, it's a similar theme, but a slightly different detail. Changes to design post-consent, but these are deliberate changes, if I could put it in those terms. So you have your in-principle scheme, or you've got your consenting envelope, and then, but it's come forward on a sort of an indicative, or this is what it will probably look like, or this is what we've assessed for the purpose of the ES on a framework basis. But there's an expectation that there's going to be refinements to the design or changes at a later stage. And I think issues are arising. This is becoming quite controversial, particularly where there is limited scope for public participation at the post-consent stage, particularly where it has been a controversial scheme as it's been going through the in-principle consent. As a recent example of this, I'm sorry, this is where we get to the first PHS2 cases. There was a challenge last summer, the Crown on the application of Grange Taylor against High Speed 2 Limited, the Department for Transport. And this was brought by a resident of Park Village East about the emerging design to the HS2 phase 1 in the Euston approaches, so the throat essentially as it approaches Euston Station. And the decision that was said to be challenged in the statement of facts and grounds was the defendant's ongoing failure to provide updated drawings and service things in respect of that design, that emerging design, and to commission and disclose an updated environmental impact assessment in relation to the emerging design proposals. And just for context, there had been some information had been put out in the public domain about the emerging design, but this was about more specific details that were being sought. And permission was refused on two of the grounds, which were the expressly pleaded grounds to do with failing to provide information and failing to provide or commission or provide an updated EIA, but it was granted on 2 human rights grounds. It was alleged there was a current and anticipated breach of those rights because there was a concern that the design that was emerging was in the view of the claimant and supported by a report that she had inherently dangerous, and would obviously cause problems for residents with houses in that area. Interestingly, in granting permission, Mr. Justice Lang drew attention to the defendant's duty of disclosure and duty of candour, and referred to some need to disclose relevant material as part of that. And there was subsequently then an application for specific disclosure for various categories of material which were granted. So in a way, although permission had been refused on grounds 1 and 2, some of that information then came through as part of the obligations that have been imposed by the court in that respect. And the claim was ultimately unsuccessful in terms of the alleged breach of Articles 8 and Article 1 of the first protocol. But it is quite interesting to see what was said by Mr. Justice Jay at paragraph 103 of the claim, which was touching back on this idea of information. And reliance was placed on I can never pronounce it, I'm going to call it the Turkey case, which was an Article 2 case. It was about an explosion, a methane explosion at a landfill site in Turkey, which resulted in some fatalities at some dwellings that had grown up around the landfill site. But part of what was stressed in that case was the importance of providing information on as part of the state's positive obligations in terms of protecting Article 8 and A1P1 rights where you might be in an environmental or an industrial danger context. And the court didn't think that we were in that territory yet, but did obviously put a warning point at the bottom that these cases should be borne in mind as future works progressed, and that effective communication remained important in the case regardless of any legal requirement. So in terms of, I suppose, the relevance or importance of this case, it is an indication that where there is obviously concern or disquiet on the part of those who may be affected and who don't see what role or what scope there is for participation in any later approvals or consents that might be needed after the in-principle consent has been given. There are different ways that can be used or may be prayed in aid by way of challenges to say, well, we need to know what's going on. By not telling us what's going on, this is a problem. So again, in terms of that, it's something that's obviously worth giving quite a lot of consideration to during the consenting process, which is if there are going to be these later details or this later consenting stage, how is that going to be communicated? What scope is there going to be for public involvement in that, to try and sort of de-risk a situation of somebody going to court and saying somebody is acting unlawfully because they're not telling us what's going on, or because they are acting outside the EIA envelope, or because they haven't checked if they're acting outside the EIA envelope, or because the local authority should be enforcing this isn't enforcing it, and we think there's credible grounds for thinking that they're outside the EIA envelope or they're outside bill or order limits. So again, it's a word of caution in terms of going through the consenting process, that it's just relevant to be aware. It's important to be aware of avenues that may be used in the future if people feel that there isn't a role for them in that subsequent consenting stage. Thirdly, and this is I suppose a particularly hot topic item, just looking at some of the news reports that have been floating around over the last few days, continued objections to the scheme and actions that people may try to take once the scheme's received consent. What actions may be utilised or available to try and stop the project in its tracks. And protest is obviously a well-known action that's used for that purpose, and it is something that's been quite high profile in respect of the HS2 works. Now, there's a couple of issues. I've jumped forward too quickly. Obviously, generally, the use of injunctions or bringing claims for possession orders of land is well established in the context of whether a protest or protests seeking to restrain development or activities. But there are a couple of particular issues that have arisen or been revisited over the last 18 months. And the first one is what you do where land is being used under temporary possession powers rather than being compulsorily acquired. And that's probably become particularly pertinent with the provisions that have come in through the 2017 Act, and obviously in HS2, the Act itself makes specific provision for temporary possession of certain parcels of land, or generally in respect of land which it could be compulsorily acquired. You could use temporary possession powers instead. And secondly, protests that involve highways. And see, the hot topic in there is Article 10 and Article 11 rights and what you do about them. So in terms of where land is used under temporary possession powers, it seems now quite clear that a possession order is available in such circumstances, even though it's a statutory possession power as opposed to, say, formally registered legal ownership title, a HMLR being a leasehold or a freehold. I'm afraid there's a slight error on the slide. The case I was intending to refer to of David Holland QC is actually the 22nd of June 2020, for which I can't yet find a neutral citation number. But that was essentially an extension of an order that an injunction order that previously been granted, but revisiting this idea of, you know, can they claim possession for the purpose of a possession order even though it's temporary possession? He said yes. And but the important point that's come up recently is it may not be available if there's not been compliance with the statutory procedures for obtaining temporary possession. So in the second case I've mentioned, there are a 2021 decision from Mr. Justice Mann. The issue there was that occupiers were said to have been in situ underground or on the site before the before HS2 or the nominated undertakers contractors had gone into occupation, and it was said that those notices should have been and hadn't been served. And Mr. Justice Mann upheld that point and said yes, this is an issue, but went on to find a different way in which he said that the claimant was entitled to possession, which was essentially that the legal owners of the site from whom they had taken possession lawfully under the Act would have had a claim against the trespassers. So the contractor did, the claimant did thereafter as well. And the second point, just touching briefly on highways, there's three cases to be aware of because it's slightly different. The first two cases have been slightly different ways of looking at the same sort of point. Secretary of State for Transport and Persons, and this was the 2019 case I wrongly referred to. It's a continuation of the same case but a different judgment, and this was about varying and extending an injunction which was directed at restraining acts which are outside the site but were preventing access to the site from the public highway, or where the public highway was being used to encroach or trespass onto the site. And David Holland QC, sitting as Deputy High Court Judge, didn't see any issue in principle with that, having reviewed the authorities on it. A slightly less willing, I think, interim injunction was granted by Mr. Justice Kerr in the case of Hillingdon Borough Council and Persons Unknown, and he was particularly concerned there that the land in question was land to which the public was entitled to have access, and there were footpaths and public rights of way running through it. So he was very, very cautious about this idea that Hillingdon should be able to restrain people using the site, and did actually cut down quite a bit the acts that, or the identity of the people who were going to be restrained by the injunction. And just finally, in this context, important to have regard as well to the recent Supreme Court decision in Ziegler, which is looking at how Article 10 and Article 11 rights fall to be considered where there's a deliberate obstruction of a highway for protest purposes, and whether that can ever be a lawful excuse in defence to a prosecution under the Highways Act. Not to give the game away, yes it can, and the court sets out a number of factors that need to be looked at in making the assessment in any given case. And just very quickly, finally, because I've had my "you must wrap up" reminder, something else to bear in mind, I've talked about legal challenges, sort of the physical protest, but of course there are legal challenges that that can be used to try and restrain works permanently or temporarily. It's an emerging trend, I think it's fair to say, of applications for interim relief to restrain works on environmental grounds. Tim's already talked about Packham. I've given you the High Court reference there because that was the stage at which the interim injunction application was being focused on. There's also been more recently the case of Keir and Natural England, in which Mrs. Justice Lang granted an interim injunction restraining the carrying out of works within a woodland, pending consideration of a challenge to Natural England's licence that it had granted for those works under the habitats regulations. And finally, obviously there's news in the press about forthcoming, or it may have been lodged, it's not entirely clear, JR to the Environment Agency regarding consents that have been granted in association with HS2 tunnel works in the Chilterns. So with that, I think it's on to Neil, and sorry I've run over slightly.
Thank you very much indeed, Jacqueline. There's a lot of good stuff in that. finally, in terms of our speakers, we have Neil Cameron QC. His very wide experience of infrastructure projects includes advising on and promoting Transport and Works Act orders at inquiry, acting on hybrid and private bills in Parliament. His work includes promoting 3 tram extensions to the Midland Metro network in the West Midlands, and his current Transport and Works Act order work includes guided bus routes, inland waterways and rail schemes. And with the benefit of that experience and expertise, he's going to tell us about Transport and Works Act orders. Neil.
Thank you, Tim. Well, Transport and Works Act orders are often seen as the poor relation in the world of infrastructure. We have more exciting procedures, DCO, hybrid bills, and even private bills. But what I'm going to try and argue today is that Transport and Works Act orders still have an important role, and in fact, the powers which the Transport and Works Act includes are sufficiently wide to make the use of the orders very convenient, and it's my argument that they should be used more widely. So, Transport and Works Act orders the poor relation, which is probably why I've got the last and lunchtime slot. So if you all decide to go and have your lunch rather than listening to me, I quite understand. Right, I'm going to start off with some history, because it's quite good to understand why we got the Transport and Works Act. So until we had the 1992 Act, works bills were promoted in Parliament. And in the past, Parliament had been quite productive. In 1838, 62 private bills were deposited in a session, and they managed to get through them. By 1991, they were struggling with half that number. And the reason for promoting the bill was explained by the then Parliamentary Under Secretary of State for Transport, Patrick McLaughlin, who went on to become Secretary of State at a later stage. And he referred to the profound changes in transport industries, and it had become clear that Parliament is not prepared, as it once was, to see numerous bills brought before it to authorise such schemes and works. Which I think he meant that MPs were fed up with sitting on committees, listening to people like me and Tim and Jacqueline and others droning on about transport orders. And so we had the Transport and Works Act. Now, it does have a wide ambit. So we got railways and tramways in section 1, and then in section 3 we have construction or operation of an inland waterway, but that is extended to works which interfere with rights of navigation. The tension between the 1992 Act and DCOs is solved, because if a DCO is required, development may not be authorised by the Transport and Works Act. So what is left for Transport and Works Act? Well, they are the smaller schemes, but nonetheless important schemes. And the Act within itself gives the Secretary of State power to extend its provisions. So under section 2, the Secretary of State may prescribe modes of guided transport to bring them within section 1. And the idea of this at the beginning was, in my view, a good one, that the Secretary of State by order could extend the ambit of the Act. It was to allow flexibility. But although an order was made in 1992 and amended in 1997, there seems to me to be a reluctance on the part of the Secretary of State to use the powers. But the powers were there for a very good reason, so that you do not need primary legislation to extend the ambit. And I've got that picture on the left of a slightly fanciful scheme, but the point of the order process is to allow the Secretary of State to, I've gone too far, to make orders. Well, here's Article 2 of the current order, and you can see the ambit. So, may make an order relating to or matters ancillary to, and then we've got a list, aerial, cableway, and so on. But what happens if you want to promote, say, a guided bus system with optical sensors? Well, you might slip it in within those provisions. I think it's quite difficult to do so. But in those circumstances, I would expect the Secretary of State to quickly make an order to enable that type of scheme to come within the ambit of the Act. But there seems to be a slight reluctance to do so. And there's a similar power for the inland waterway provision. So the Secretary of State can make an order, has done, but again, we're back on a 1992 order, and I say and ask rhetorically, why has the Secretary of State been reluctant to extend the power of these provisions? So, what is the current ambit? Well, DCO projects are excluded, otherwise the regime is wide, and as I've already said, the Secretary of State has power to make further orders. And given the government's levelling up agenda, which I expect we're going to hear even more about following the recent changes, and their transport-related infrastructure initiatives, and I have in mind documents such as Bus Back Better, which is encouraging guided buses, pointing out that it's a cheaper way of achieving efficient public transport than the tram systems, and they refer to the Cambridge experience and Belfast experience. And I would expect that if one's going to have those guided bus systems, we need to be making some Transport and Works Act orders. Simplest, most efficient and best way of facilitating these schemes, and doing so relatively quickly. I now turn to rather than the ambit of the powers, the extent of the powers. Well, they are quite considerable. We've got all the matters in Schedule 1. We've got the model clauses, which gives us an indication of the powers. And as you all know, it includes compulsory acquisition, stopping up of highways, street works, etc. All the things you need to do if you're going to promote a transport scheme, such as a tram or guided bus system, or, although I hesitate to mention it, having had a bad experience, a trolley bus system, although I don't think we're going to see any of those being promoted. And of course, you can get your deemed planning permission. And the power, this is another power which I think is underused. Section 15 enables orders to be made and regulations to be made, assimilating other procedures. And that's been done for heritage assets, and I set out the regulations there. It's been done under the Transport Act, that is for classification and maintenance of inland waterways, and by classification, is it commercial, is it leisure? So that's been done, but that power could be used much more extensively. There's another power here in section 5.3. Well, this is a very wide power. I won't read it all out because you can see it, but a Transport and Works Act order can apply, modify, or exclude any statutory provision which relates to any matter to which an order could be made under section 1 or section 3. So, for example, you might have some works which are going to be consented under a Transport and Works Act order which require a marine license. Give that as an example. Under the DCO process, there's a deemed consenting process. There isn't one under the Transport and Works Act, but this provision would be wide enough to allow for that. But the Secretary of State has said in the now out-of-date guide to procedures that he's only prepared to agree to disapplication in exceptional circumstances. Well, I again ask, should not that be reconsidered? Because the power's there, it can be used, you have to go through a formal procedure, and it would make the system much more effective in achieving a one-stop shop. So what are the advantages and disadvantages of Transport and Works Act? And I'm thinking particularly compared to a DCO. Well, you've got to have an inquiry, which can be lengthy, it can cause delay, expense, and require the attendance of witnesses for many days. The reason I put that last point in is often you get a senior local government official who has to be engaged in the process for many days when they've got other important duties to perform, and that's a major disadvantage. But there are also advantages. For an inquiry, there are clear rules for statements of case and evidence, and a promoter can, of course, use the initial part of the inquiry to establish justification, and for objectors, they have a right to be heard. And it allows for a thorough examination of the scheme, and that is what Parliament sought to achieve when it hived off these orders to this Act. What about the influence of policy statements? I think this is quite interesting. There's no equivalent to the provision in the Planning Act in relation to national policy statements. Section 38(6) does not apply. That was decided in a case relating to an Electricity Act order. Therefore, a flexible approach can be taken. And I think that is a major advantage of these orders. Yes, the inspector, when writing the report for the Secretary of State, will have regard to local policies, but there is a very high degree of flexibility, which means that this is an entirely suitable process for a good scheme which needs to be consented without too much delay. So, in conclusion, it's my view that the system established by the Act does achieve its intended purposes, but it could be used more flexibly to make it more effective in operation. And if the government wants to encourage local transport schemes, such as guided buses or trams, to put into effect their plans for levelling up, investing in infrastructure, and so on, then I would urge them to use the system more flexibly. Use the Section 2 powers to make more orders. Use the Section 15 powers for assimilation of other procedures. Reissue the Guide to Transport and Works Act procedures, and perhaps in that guide, remove the reference to exceptional circumstances when considering Section 5(3). And how can you make the inquiry process more effective? Well, you can use effective case management. You can use, and I think they should use, round tables more effectively, as happens with planning inquiries, subject to the agreement of the parties. But that will be entirely suitable for some parts of the scheme and would save a great deal of time and therefore delay. And for promoters, make more use of Section 5(3) so that it does become an effective one-stop shop. And that's it. And that's for you to choose whether you'd rather be down on the ground in one of those cars or up in one of those pods, approved under a Transport and Works Act order. So that's it from me.
Thank you very much indeed, Neil. I very much share your thoughts about the potential usefulness of Works Act orders. As you know, and others will know, I have been involved in procedures in relation to rail projects, and I think it's quite a. I think it does have a considerable advantage, certainly potential advantages in the field of infrastructure planning. Now we have one or two questions that I think we can take just before we close, and the first one is a question from Morag Thompson, which I think Jacqueline is going to answer, which is, why can all the elements on slide 7 of Jacqueline's slide not all be included in the development consent order itself? It's all within the scope of section 120 of the Planning Act 2008.
I'm working on the basis this is a reference to the public rights of way slide 7 and the things that can be included in a side agreement. I mean, I think the short answer is that my experience tends to be that those who are promoting or applying for orders tend to resist more being written in than they consider needs to be, or that goes beyond what's been provided for in earlier orders or in model provisions. So in principle, perhaps those points could go in. It's more there tends to be a resistance on it, and the side agreement may be the more practical way of getting that as an outcome, rather than sort of fighting through the consenting process as to whether it ought to be written into consent. I do just note on that I think the former model provisions, or the model provisions that they used to be for the 2008 Act, did have something in, I think, the suggested provision 10 on public rights of way, which referred to an implementation plan. So referred to things being done in accordance with an implementation plan, the implementation plan being a written agreement between the highway authority and the promoter or the applicant as to how that was to be, how those things were to be taken forward. But obviously there isn't anything comparable in the Transport and Works Act order, or the model provisions that apply there. So it's more a sort of experience point that people tend to try and resist these sort of things being written in. So in practice, you probably get the same effect by doing it in a side agreement, but you may want to consider whether you put something in the consent itself which expressly refers to the side agreement to secure it in that way.
Thank you. I'll take a couple of questions, I think, that arise out of my talk. The first of those comes from Patrick Walker, who said, in practice, some key ministerial statements on planning matters can end up being treated as equivalent to national policy by planning inspectors in reaching decisions. Do the principles of the Plan B judgment create a wholesale risk for all ministerial statements used in this manner at section 78 planning appeals? I think the answer to that is no, certainly not necessarily. A point that I sought to emphasize, and I emphasize now in relation to the reasoning of the Supreme Court in their judgment, is that they rooted their explanation of what was meant by and what was the scope of government policy in the statutory context in which that phrase arose in section 5 of the Planning Act. And it doesn't follow that the scope that they gave to government policy in that statutory context is one that applies to a quite different statutory context. In the context of section 78 appeals, the duty of the decision maker is to have regard to all material considerations, and the question whether a given written ministerial statement falls within the scope of that definition is the relevant question. I think it's fair to say that the broader concern that the Supreme Court raised about trawling through press statements, trawling through Hansard in order to identify things said by government ministers, and then converting that, if you like, into something that should carry weight in the same way as the relevant provisions of the National Planning Policy Framework. That is a general point of approach, which will need to be considered and may have a bearing on whether a ministerial statement or a press statement should be treated as have any significant weight or bearing on the policies that are against which a planning application or a planning appeal is determined. But I don't think you can say that there's a bright line, if you will, that emerges from the Supreme Court's decision, which applies across it applies to the understanding of planning policy across the planning field. I don't think that is right. It was focused upon a particular statutory context in Section 5 of the Planning Act. The second question is from Mr. Gorst. Where is that? I've lost that question, but here we are. Mr. Gorst asked whether the recent decision of the Secretary of State to concede to judgment in relation to a development consent order for works to the A38 road in Derby, whether that places a question mark over the determination of any future highways development consent order. My understanding of the basis upon which the Secretary of State agreed to that decision being quashed was that the Secretary of State had not addressed and given his reasons for dealing with a matter that was left over to him to consider by the examining authority. The examining authority had not failed able to draw any conclusions about the impact of that scheme on climate change considerations. And the Secretary of State in his decision didn't deal with that, at least to the requisite level of detail that would be needed, given that it had been left by the panel for him to address. I think, therefore, that what that decision does is to indicate that, firstly, as I said in my talk, the impact of particular schemes on climate change and the achievement of the government's objectives is extremely important as a factor that needs to be addressed in detail in the evaluation of the scheme and its promotion. But secondly, a more case-specific point, that where the examining authority or inspector in another context doesn't feel able to draw conclusions of their own in making their report to the Secretary of State as decision maker, then obviously the decision maker must decide how they're going to address that gap, either by seeking further advice or by dealing with the matter in rather more detail than they perhaps would if they were simply accepting the reasoned recommendation of the panel, the examining authority, or the inspector. Now we have a question which I think is for Neil, which comes from Matt Gilts. Whilst
sorry.
Yes, no, Neil, go on and deal with that if you would.
I think there are two which probably come to my door. One person asks what's the case which establishes my point that Section 38(6) does not apply when determining a deemed application for planning permission. And the answer to that is the Queen on the application of Samuel Smith. It's one of the countless Samuel Smith cases, this time against the Secretary of State for Energy and Climate Change, 2012 EWHC 46. And if you're really interested, have a look at paras 79 and 80. And the other question was, while the TWA offers flexibility when compared with DCO procedures, what policy provision would be required and over what period might one expect a policy provision to emerge? The short answer is, don't need any policy provision. The Secretary of State has the discretion to make orders to extend the range of projects, both for transport projects and for inland waterway projects. The Section 15 power is there to assimilate procedures. The Section 5.3 power is there. So I don't think you need a grand policy statement. I think it would be helpful to reissue the guide to procedures and to get rid of that exceptional circumstances policy on exercising section 5.3 powers. It's a very long answer saying you don't need any.
Thank you, Neil. Jacqueline, I don't know if you can see, there's a further question for you, I think, on the question of public rights of way. Have you spotted that one?
Yes, I have. Thanks, Tim. And I was just looking something up on that. This is essentially a question about whether you import the tests from the Highways Act when you're looking at, I think, section 5.6 of the Transport and Works Act, or the section 136 of the Planning Act 2008. And my view on that has always been that you don't, because the test is what the test says. The test is set out in the statute as to what the Secretary of State must be satisfied of to authorise to allow for the stopping up or diversion of the right of way as part of the order. There was debate about this during the inquiries into Transport and Works Act orders seeking to reduce the level crossing estate for Network Rail in Anglia. And I know this was dealt with in the Secretary of State and the Inspector's report, and I was just quickly trying to see if I could find the answer to it. I think from recollection, but that's always a dangerous thing, the Secretary of State sort of accepted you have a 5.6 test, which is the 5.6 test. Essentially, it's a condition precedent. And if you want to, you might get into issues, things like immunity or public enjoyment when you get to the overall weighing up of the public interest of the balance test, because there the scheme was all about whether or not these crossings should be shut. But I certainly haven't read those as saying that you import Highways Act tests into the statutory provisions that deal specifically with public rights of way in the two acts that we've been dealing with here. But I will double check that, and if I'm wrong, I will try and send a clarification round when the slides go out with later on today.
Thank you very much. I think there's one time for us to deal with one more, and that's a question that was, I think, left over from the morning, the earlier session, from Robert Gillespie. I'll see if I can just deal with that. It arose in relation to Heather's talk, I think. Robert said the sheer cost and delay associated with evaluation of proposals and the alternatives is undoubtedly a fundamental influence over the extent of technical evidence and material produced. Proportionality surely must be another factor, but how and who makes that judgment given the potential vulnerability to legal challenge? Is there any guidance as to what the reasonable parameters are considered to be? I think the question as to who makes that judgment starts with the promoter, because the promoter bears the risk that the scheme that they bring forward will be judged against an alternative that is argued for by an objector to the scheme, and that they will be found not to have evaluated that alternative properly, or that they face the risk that that alternative, upon comparative consideration by the decision maker, the examining authority or the Secretary of State, will be found to appear, at least, to give a better solution environmentally and in other respects to meeting the need than the scheme that is before them. How does one manage that risk? One manages it through the statutory procedures, and that obviously begins with the identification of alternatives that ought to be considered as part of the environmental assessment process. The best way to manage the risk that your scheme will be found and will be criticised against the performance of alternatives is to ensure that your evaluation of that alternative at the environmental assessment stage is as effective and robust as possible. What the message from the Stonehenge decision, I think certainly as I understood Heather's analysis of it, was the risk is thinking that once you've carried out the environmental impact assessment of alternatives, you need do no more. That, of course, is a dangerous position. And so the next and vital stage is, having carried out your environmental impact assessment, you need to be ready to provide a continuing evaluation, comparative consideration of the performance of your scheme against any alternative that is argued for strongly through the examination process, so that you can not only show that you've carried out the environmental assessment, but that you are able to justify to the decision maker that you've chosen the right scheme and that the alternative is suboptimal to the scheme that you're arguing for. So the message of Stonehenge is don't stop the environmental impact assessment, carry on and keep the alternative, and certainly keep an alternative that is seen as being clearly in play through the examination process. Make sure that you have the evidence that you need, and you put forward the evidence and the argument that you need to put forward to justify your scheme as the optimal solution against that in the face of that alternative. And I think that concludes certainly answers the questions that I have in my box. With that, it remains only to thank each of our speakers for their helpful and informative talks during the course of this seminar, but also, and very importantly, to thank all of you for attending the seminar. We're always grateful for your attendance. We hope you found it helpful, and as I announced at the outset, we will be providing a link to the recording and the slides, and I think we can also provide details of the case references that were asked for earlier in the cases about the assessment of alternatives, which Heather mentioned, were considered by Mr. Justice Holgate in the Stonehenge recent Stonehenge decision. So with that, we'll wish you well for the rest of the day, and I'll close this webinar. Goodbye.